Your hearing for appeals and said Michigan Down Sections. The Honorable Michael J. Reardon, the Honorable Philip P. Mariani, presiding, the Honorable Daniel Anthony Corruption, all person have business hearing, draw near, and shall be heard. God save the United States, the state of Michigan, and Honorable Court, please be seated.
Thank you very much, and good morning, everyone. Welcome to the Michigan Court of Appeals. This is the first day of case call for panel 4 of this court's May 2026 session. Not sure how we got to May 2026 so soon, but here we are. My name is Dan Korobkin. I'm joined here today by Judges Michael Reardon and Phil Mariani. We're very pleased to be here. Couple of things before we get started. First, we understand that these cases are important to the litigants and to counsel. I want to assure you they're important to us as well. We have been diligently working on these matters. We've had the benefit of your briefing, of course, as well as the work of our excellent research division and our own chamber staff. We are familiar with the facts and the law. So we ask you to focus oral argument today on your most important points, why you should prevail, and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. And because these proceedings are recorded, we ask that you please use initials when referring to those individuals rather than the actual name of any victim, child, or other vulnerable individual in those cases. Okay? With that, we look forward to hearing your arguments, and we'll begin by calling item number 1, docket number 372400, People versus Herbert Aloysius Benedetti. And I believe we have Ms. Pajak endorsed for oral argument, and she is remote. We also have a remote appearance for the prosecuting attorney. She's not endorsed, but she is here so that she can answer any questions that the panel may have. So I see both of you here. Good morning. And Ms. Pajak, whenever you're ready.
Thank you. Good morning. And thank you for letting me appear by Zoom. Christine Pajak, on behalf of Herbert Benedetti, do not have much to add to the briefs. You will recall that Mr. Benedetti was convicted of fleeing and eluding and resisting a police officer. He was sentenced at the very top of the guidelines. His sentence was disproportionate, even though it was within a guideline sentence. The only information the court had at the time of sentencing was the pre-sentence report. We moved for resentencing and provided a report offering mitigating evidence that the trial court felt was not really mitigating because it did not look past Mr. Benedetti's criminal history. But that considers only part of the picture of Mr. Benedetti and what the court is supposed to consider, which is, the facts of the offense and the offender. I acknowledge Milborn and this court's recent opinion, and I hope I'm not going to butcher it. I probably will. Brichik, both indicating that a longer criminal history is an important factor, but also important is the other circumstances of Mr. Benedetti, the offender, who has documented mental and physical health issues, and is argued as in the brief, the mitigation evidence provided shows that the sentence was disproportionate. He should have gotten a sentence lower within the guidelines, and trial counsel was also ineffective for failing to present this earlier.
Yeah, I read the report that you prepared for the court and your motion for resentencing, which was outstanding. The person who wrote it did a wonderful job. But one of the issues you raised up, that there was nothing mentioned about his volunteering at Open Door, or that he had to live in his van for a time. Both of those were in the pre-sentence and investigation report. I read that as well. Those were also included. So those are two of the mitigating circumstances that you raise on appeal as well. The court's already considered those.
The report, as you know, was more in depth, and there was more information than just those pieces, I think, Your Honor.
Well, Open Doors
And-
up in Midland County, and the judge is from Midland. It's not an overly big area. You would think that he would be familiar with Open Door.
Right, but he might not have been familiar with all of Mr. Benedetti's involvement with Open Door.
Well, it did list it in the PSIR, his involvement in Open Door. But, okay, thank you.
Thank you.
Else? No? Okay. Thank you very much, Ms. Pajak.
Yeah.
Does anyone have any questions for Ms. Is it Duso? Yes. Any questions for prosecuting attorney? No? Okay. Thank you very much both for being here. We will put that case under submission and try to get you an opinion as soon as we can. Thank you very much.
Thank you.
Thank you.
Okay, that case is submitted. We are moving on to item number 2, docket number 368192, People versus John Clint Birch. Good morning.
Your Honor, before I put my appearance on the record, Mr. Birch has 2 appeals before the court today. This first one in which we are the appellant and the next one in which we are the appellee, which is a first for me in 20 years.
It took a while for me to figure that
Yes.
out, and to see these
Actually,
Butzel Long attorneys on it, I'm thinking, wait a minute,
Yeah.
the prosecutors now?
And I believe the court may have consolidated the
yes,
cases.
actually, thank you very much for reminding me. Let me just, for the record, we're going to call both cases docket number 368192 and docket number 374419. Both of those are People versus John Clint Birch. Thank you.
So and I was just going to ask the court for instruction. Is it acceptable for me to argue both cases while I'm up here?
Please argue
And we'll
both.
just stay at our respective tables and, okay.
Yes.
I just wanted some instruction from the court before I started. Thank you. Okay. Good morning, Your Honors. May it please this honorable court. Alona Sharon on behalf of Mr. Birch, who is the appellant in the first case and the appellee in the second case. Your Honor, if it's acceptable with the court, I would like to address the sentencing issues first, and that is the case in which we are the appellee. Mr. Birch successfully filed a motion to correct an invalid sentence challenging the scoring of OV11 and the legality of his consecutive sentences. The trial court agreed with Mr. Birch, vacated the sentence, engaged in resentencing, and Mr. Birch received a significant reduction in his sentence. I do just want to, although I think the brief is fairly thorough, I do just want to address 2 points from the prosecution's brief. The prosecution, with all due respect, Your Honor, I think very much misrepresents the trial court record in its argument that the reversal of OV11 was improper. Probably most important is the allegation or the assertion by the prosecution that DT, the complainant or victim in this case, testified at trial that she was digitally penetrated by Mr. Birch. That is absolutely not correct. And if the court turns its attention to my brief in this docket, pages 10 to 12, there are numbered bullet points that really break down exactly what this victim testified to. She couldn't remember the age of when the assaults happened. She was either 12 or 13, that she was, that Mr. Birch put his penis in her vagina. It happened 2 or 3 times. Other than that, she could not remember any of the specific incidents of sexual abuse. When asked if she remembered anything else about him putting his penis in her vagina, she said no, that she couldn't. When asked if anything happened while he penetrated her vaginally with his penis, she said no, just that my sisters would come into the room and that would cause Mr. Birch to stop the assault. She was asked generally how Mr. Birch touched her, and she stated he would put his hand on my breasts and he would put his penis in my vagina, which that part we already knew, but that was not in reference to any specific allegation. This court knows that in order to score OV11, there must be additional penetrations, not a touching, arising out of the offense that's being scored. There is no testimony from DT that there were additional penetrations at the same date, place, and time, which is held this court has historically defined arising out of the same transaction. The suggestion by the prosecution that she testified at trial that she was digitally penetrated at the same time that the penis to vagina penetration happened, the convicting offenses, is absolutely false, and it is a misrepresentation of the record. The trial court was correct when it vacated the scoring for OV11, and the sentence is proper. Turning to the consecutive sentence issue.
My understanding of what the prosecution was arguing, and of course we'll give them an opportunity to argue it, is that given all of the testimony on the entire record, although maybe the testimony wasn't very express or explicit, it's quote unquote more probable than not that that the additional penetration was at the same time. And the trial judge said, I don't think so. I don't find evidence for that. That's kind of my interpretation of what the two arguments of this.
I agree.
Yeah.
I agree that that's what the argument is. I suggest to the court that there is no merit to that argument. And I also think that given the standard of review, the trial court's reading of the record is appropriate and is not worthy of overturning. Because
I mean, we'd have to find that finding by the trial court was clearly erroneous.
Correct.
The trial court was almost required to make those findings.
Correct.
Yeah.
And I don't think that they can meet the standard of clearly erroneous or clear error. As to the issue of consecutive sentencings, I do just want to, first of all, I argue in the brief that the issue is waived because frankly, with all due respect to the prosecution, there is literally no legal analysis in this portion of the brief. And this court has repeatedly told parties, it's not our job to do your research and make your argument for you. If the court isn't compelled by that argument, I think that the prosecution's brief very much demonstrates a total lack of understanding as to the discretion, how the court gets discretion to impose a consecutive sentence. Under the statute, the two convictions must arise out of the same transaction. And what the prosecution does here is relies on its argument of why the scoring of OV11 is wrong to then kind of impute that to the consecutive sentence. That makes, frankly, no sense whatsoever because the argument on the OV11 is that a reasonable reading of the record is that she was digitally penetrated at the same time that the vaginal penetration happened. But the convicting offenses are two instances of vaginal penetration. So there would have to be evidence in the record that these two incidents of vaginal penetration arose out of the same transaction in order for the judge to have legal authority to impose discretionary consecutive sentences. That absolutely does not exist in the record. And for that reason, their argument must fail. Now, shifting gears to the case in which I'm the appellant, Your Honor, I think the brief pretty much touches on all points. The trial court made the finding that trial counsel, Mr. Tamal, his performance was deficient for not objecting to the statements by Dr. Girton. And I think something that kept getting sort of mishmashed at the Ginther hearing was that Mr. Tamal kept trying to testify or did testify that what Mr. Birch wanted was Dr. Girton's findings to be admitted. And that's fine. I have no problem with that. But then there's this conflation of, well, in order to get his findings in, the statements that the child made to him have to come in. And that just makes no sense. I mean, Dr. Girton examined this child 14 months after the allegations with no complaints of pain, symptoms, illness, anything. 8034 does not apply in this context. And so he was deficient for failing to object. So then we turn to prejudice. I can't dispute that Mr. Birch made some very incriminating statements. However, what is different in this case is that Mr. Birch then at trial took the stand and he testified and he tried to explain to the jury why he made the admissions that he made. And so in my opinion, respectfully, that just reverts the case back to a credibility contest. Are they going to believe Mr. Birch, who made incriminating statements, but then takes the stand and tries to explain why? Or are they going to believe the complainant whose testimony is bolstered? I mean, the trial court made an explicit finding that repeating the statements to Dr. Girton corroborated and bolstered the victim's statements. And so the question is that going to prejudice the outcome of this trial? And I think this court and our state Supreme Court has repeatedly found
Didn't
that.
the appellant in this argument, didn't he ask for that report to be admitted?
So,
He requested his counsel
okay, so
to enter that into evidence.
I take issue not with what Your Honor is saying, but with Mr. Tamal's characterization of that. Because if you read the testimony from the Ginther hearing, as I'm sure the court has, I lose track of how many times Mr. Tamal flip-flopped between I advised my client about the hearsay rules, I didn't advise my client about the hearsay rules. My client insisted that the testimony come in. I told my client it was a bad idea. There is no consistency in Mr. Tamal's testimony. But more importantly, Your Honor, what I think comes out of the Ginther hearing is that what was important, and I think I already touched on this a little bit, what was important to Mr. Birch was that Dr. Gurton's findings come out into the trial, that there was no blood, that there was no injury, that there was no evidence of sexual assault. And to get any of that in, there's no need to repeat the allegations from DT, from the victim. That's absolutely unnecessary. And that's why it's sufficient performance. And so when we revert back to a case that is a credibility contest, the standard for showing prejudice is lower because we have no corroborating evidence. And for that reason, I do think the outcome of Mr. Birch's trial was prejudiced and that his convictions should be vacated. Thank you, Your Honor. Your Honors.
Can I ask one
course.
question before you leave? It seems this is complicated because of what Judge Reardon said is that there was some, I agree with you, the testimony is a little bit, it's a little bit difficult to make out, but there's certainly testimony that the defendant wanted something, was insistent on some parts of the report or
Sure.
the testimony. Don't you have to demonstrate that if that in some way the defendant had his advice from counsel been different, the defendant would have not, would have wanted to keep out the identification testimony, because there's not really anything. I mean, I think you're asking us to infer that. I think that had counsel not been deficient in the advice he was giving to his client would have said, "Oh yeah, let's redact that let's object on hearsay grounds."
Well, I don't think that showing is required because I think what comes out of the Ginther hearing is that Mr. Birch wanted the doctor's findings, not her statements. I think when you look at Mr. Tamal's testimony, his testimony, in the one instance in which it's clear, is that he wanted Dr. Gurton's findings and that he thought the findings, if you look at the brief, Your Honor, I give a numbered list of why Mr. Tamal said getting that information in was important. And it all had to do with the fact of the findings, that there was no blood, that there was no injury, that she wasn't suffering pain. And I think that she didn't have she tested negative for all the STDs. None of that has to do with statements that this child made to Dr. Gurton. So that's why I think I don't have to be able to answer that question, because when you look at Mr. Tamal's testimony, the one thing that's clear is that Mr. Birch insisted on the findings, not on the girl's statements coming in. Thank you. Does that answer your question?
It does.
Okay.
Thank you.
Good morning, Your
Good
Honor.
morning.
Steve Etherly on behalf of the people, serving as a special assistant prosecutor on behalf of Clinton County. Your Honor, I'm going to start with the people's cross appeal because counsel started with the cross appeal. Your Honor, the cross appeal, it only involves defendant's request to correct the invalid sentence. It's specifically the reversing scoring of OV11. It's important to note that it's a preponderance of the evidence standard when scoring OVs. The parties had agreed to the OV scoring, which included 50 points under OV11. There's no dispute that OV11 doesn't count the conviction penetration. Your Honor, it's important to note that this case involves a narrow sample size. Defendant signed a written confession that he raped the victim 2 to 5 times in the bedroom, and victim testified that she was raped on 2 to 3 occasions. And again, these all occurred in the bedroom. I take umbrage with with the argument that the people are misrepresenting the court. There were two categories of other criminal penetrations that could have been charged as crimes. The first being the digital penetration. The testimony supports that defendant digitally penetrated the victim's vagina. In the testimony, the question was, did defendant ever do anything with his fingers to your vagina? The victim testified yes. But Dr. Gurton's report, which there was no dispute that was entered into evidence, and it was dictated in front of the victim, confirmed that victim nodded positively when asked whether defendant's fingers went inside her vaginal area. Also, Dr. Gurton testified that when we asked about his hand, the victim indicated that he fondled her genital area and did insert a finger into her genital area. So we have the digital penetration, and second, we have the fellatio. The fellatio, although the victim at trial, and again, this was 3 years after the rapes had occurred, testified that she did not remember performing fellatio on defendant, victim reported to Dr. Gurton that she had been made to do so and that defendant ejaculated in her mouth. And again, that report was made just over a year after the rapes had occurred.
I guess I didn't understand the trial judge to be saying that those things didn't happen. The trial judge seemed to think that there was no evidence that as to when they happened, which is what you need under OV 11, right? That it was the that it arose from the offense of conviction.
Correct, Your Honor. So there is that time sequence in OV 11.
And I took your argument to just say, well, the trial judge should have found by a preponderance of the evidence that it was more likely than not that they occurred at that time. And the trial judge didn't, right? Judge said we don't have a preponderance of the evidence.
Your Honor, I'm going to answer the question. Yes, it is a preponderance of the evidence standard. It's important to note that the parties first agreed to the scoring of OV 11 and that defendant filed a post-judgment motion. Defendant had the burden to overturn that invalid sentence. So it's still a preponderance of the evidence standard, but the defendant had the burden to overcome that invalid sentence. Yes, for OV 11, again, going to the time sequence, there is a temporal element for OV 11, and I think it's a stronger case compared to some of the other cases that are out there that there's only this narrow sample size that defendant admitted to 2 to 5 rapes and that victim testified to 2 to 3 rapes. So we are looking at, and again, it's tough subject matter, but explaining this small period of time and this small sample size. There were, and again, although these are not instances of penetration for OV 11, there was the testimony about the fondling of the breasts and the mouth on the breasts. These again go to evidence for other sexual acts committed within that 2 to 3 range or 2 to 5 range.
But you can't score OV 11 for those acts in and of themselves. You're just arguing that because those acts were committed, it's more likely than not that the penetrative acts were committed?
Yeah, yes, Your Honor. The people are not arguing that the touching of the breasts and that those are grounds of that was penetration.
It's just circumstantial evidence that penetration occurred.
Correct, Your Honor. And another thing going with the procedural and how the trial court decided this piecemeal with first deciding the sentencing scoring and the consecutive sentencing and then deciding the Ginther hearing. It's important that the people were not given an opportunity to have an evidentiary hearing to explore the victim's evidence on that temporal element. So at a normal sentencing, so at the original sentencing, when the OV 11 was all agreed on, there was no opportunity then, or there was no there was an opportunity, but no, there was no argument or there's no point for the government to put evidence to show that temporal element. There was no dispute. Whereas when the judge says that she changes her mind and says OV11 should be scored the other, 0 points for OV11, the people should have had an opportunity for an evidentiary hearing to present evidence going to that temporal element. So unless the court has any other questions on the OV11, I'm going to move to consecutive sentencing. Your Honors, again, the trial court originally sentenced defendant to consecutive sentences of 225 to 480 months following his conviction of the 2 counts of CSC 1. Sister counsel argues that we're arguing that, just because the court ruled on the scoring of OV11, that also applies to the consecutive sentencing. It was the trial court that relied on the scoring of OV11 and then saying that she does not have the authority to impose consecutive sentencing. So the people are in agreement with sister counsel that the OV11 and the consecutive sentencing under 750.52B3, that these need to be separate and distinct inquiries. Now, with the CSC 1 case, there is overlap within the Venn diagram sometimes, but not always. So it is important that the judge should have made a separate inquiry on the consecutive sentencing and on the OV11.
So let me ask, is there a way you win on one and not the other?
Is there a way we win on one and not the other?
I mean, I understand analytically what you're saying and, the separate inquiries, but just for purposes of the facts that we have here, is there a way that the court was right on one, but not the other?
I do think there needs to be that remand for that temporal element. And I do think, I'm not trying to get around the question, but I think there is significant overlap in this case with the OV11 and the consecutive sentencing, because they both have that kind of shared test. I don't think it's the same, but it's very similar.
Yeah, I mean, obviously sometimes you have different tests that just with the facts of the case you end up writing together basically and along the same analysis. And I was curious if you see a way that these paths diverge at all, for better or for worse, for your 2 arguments under the facts that are here.
I don't necessarily have a thought process, because it is just criminal penetrations at issue. I could see a case where, there's a breaking and entering and then there's a criminal penetration. But when we're only looking at penetrations, I think it's a separate inquiry, but probably the outcome would remain the same.
Okay, understood. Thank you.
Yep. So again, sister counsel is correct that, there may be overlap, but these are separate tests. At sentencing, the first sentencing, trial counsel essentially conceded that the court had authority to impose consecutive sentencing by his argument being that the court should not impose consecutive sentencing. So trial counsel was arguing that the court shouldn't exercise the discretion, not challenging that the court had the authority in the first place. So there's no dispute that there's no dispute that the trial court has discretion under the statute. It says may order, not must order. But the trial court has already signified that she would enter consecutive sentences when authorized, because she already did so. Defendant, again, kind of going back to the procedural piecemeal issue, defendant had the burden when challenging the alleged invalid sentence. Defendant's sister counsel's argument was that there are no facts in the record to show that there should have been consecutive sentencing. defendant was trying to seize on the victim's testimony that this was not, facts specific on timing. Despite defendant moving to invalidate the sentence, the burden was improperly shifted to the people, and the people were not given the opportunity to present evidence going towards those the penetrations for the consecutive sentencing. So, but that's not to say that the record is absent of any trial court testimony going to the other penetrations. There was trial testimony that the penetrations occurred in the afternoon and at night. There was no follow-up on whether that was the same exact day. There was also trial testimony that at least on one occasion, and that sister counsel admits at this argument, that the defendant and the victim were engaging in these acts in the bedroom, and that a sibling came in and interrupted the action. Now, if we have a remand for whether the court should impose that consecutive sentence, we could put witnesses or the victim on the stand. After that interruption, did you restart the sexual acts? I mean, these would go to penetrations that would count for, consecutive sentencing for those CSC convictions. So again, because the trial court decided this piecemeal and the people were never given the opportunity to present evidence going to the OV11 and the consecutive sentencing, they should be given that opportunity. Your Honor, so I will then go to defendant's direct appeal, unless we have any questions on the cross appeal. All right. So it's for defendant's direct appeal, it's only deficient, ineffective assistance of counsel. I believe it's important to contextualize the uphill battle that trial counsel faced. Defendant confessed in writing to criminally penetrating a minor 2 to 5 times during a voluntary non-custodial interview. Defendant later recanted and insisted he never raped the victim, and he argued that she was lying. So to cast doubt on victim's story, trial counsel employed a reasonable strategy and did so, as the court already highlighted, at defendant's insistence. That defendant wanted the jury to hear that victim had told Dr. Girton that there was no vaginal bleeding during the criminal penetration, obviously because bleeding is common for females during the first sexual intercourse. Defendant also wanted the jury to hear that Dr. Girton found no evidence of an injury to the victim's genitals when he examined, and that there was an absence of injury. I should highlight that defendant at this time is 5'10", 285 pounds, and he's on top of and penetrating the victim, who was a little girl of 5'1", weighing a mere 90 pounds, so a nearly 200 pounds heavier than the victim. So I think it's clear why defendant would want that helpful evidence for him that there was no injuries that occurred.
I think your opposing counsel was arguing that they could have put all of that in, but kept out the identification testimony. What's your response there?
The identification.
Any testimony that Dr. Guertin was making about about the fact that it was defendant who was accused of this offense, right? All the medical stuff you could still bring that in, but also keep out the fact that the victim said it was defendant who did this.
Yeah, I understand sister counsel's argument. And I think the Ginther hearing shows a good exchange between what Mr. Tomel was saying. And Mr. Tomel's point was he'd rather have it come from Dr. Girton, confirming what victim's story was. So trial counsel, there's a timing aspect to that. Victim testified and then Dr. Girton testified. And trial counsel wanted Dr. Girton to confirm the testimony from the victim, whereas appellate counsel would have been fine and satisfied with just the victim's testimony alone. So that exchange in the Ginther hearing, I think, is important because that shows the Monday morning quarterbacking between what trial counsel would have done and what appellate counsel would have done. And Your Honor, the people don't concede that the hearsay was inadmissible at the Ginther hearing, and defendant has never addressed whether the Dr. Girton's report, which is essentially a SANE report, a sexual assault nurse examination report, on whether that is a business record. There is case law from this court saying that SANE reports can be admissible as a business record. So again, another point that the court has already addressed was that defendant insisted on this action. I would highlight that it would be deficient performance if Mr. Tomel, the trial counsel, would have ignored defendant's wishes and didn't try to get this information into evidence that defendant believes supported his position.
But doesn't he have to, in order to perform effectively as counsel, don't you have to provide legally correct advice? So if in fact there was a viable objection to the admission of this information and the defendant never knew that possibility of an objection was out there because defense counsel never told him, that could be deficient performance regardless of whether ultimately the defendant would have insisted on putting it in.
Yeah, respectfully, Your Honor, if that was the record, in the Ginther hearing shows that there were discussions about the hearsay issue. So if the situation was that Mr. Tomel just did not explain this or address it with his client, then yes, I think that may be going towards deficient performance.
But you're saying the Ginther hearing shows that he did discuss it and his client still made the decision.
Yes, that defendant still insisted on that they should go forward with this litigation strategy. And it's important that the Sixth Amendment speaks of assistance of counsel. Assistance is the important part there. Your Honor, and I'm not going to belabor the points because I've mentioned this many times, but the trial court was correct that defendant could not prove the prejudice. There was that written confession that is a significant piece of evidence. The defendant did testify at the trial, and his attempt to argue away that written confession was that he was tired, was that he was stressed, was that he did not sleep well the night before. So the jury doesn't leave their common sense at home. They chose to ignore that, that those are good excuses for admitting to multiple rapes of essentially his stepdaughter in their bedroom. So there was enough evidence to show that defendant was not prejudiced by, even if there was deficient performance. And unless the court has any questions, I'll step down.
Okay. Thank you very much.
Thank you.
Rebuttal?
Very briefly. Your Honor, a couple things. First of all, opposing counsel references an evidentiary hearing that was needed and improper burden shifting. prosecution never requested an evidentiary hearing. I mean, we had a whole motion hearing on this motion to correct an invalid sentence. Never at that time did the APA say, hey, can we have an evidentiary hearing? There's no motion to remand before this court. There's no request for an evidentiary hearing. So I have no idea where this is coming from. This argument is nowhere in its brief on appeal, and I think it's inappropriate before the court today, as is the argument regarding improper burden shifting. That is also nowhere in the brief on appeal as it relates to sentencing, and it's improper to bring that up before your honors today. The second part that I want to address, when the trial court ruled on the motion to correct an invalid sentence, and of course your honors have that transcript, if you look at pages 16 to 17, the court very clearly said, I remember this case, I remember the testimony of DT, and the lack of specificity and the lack of clear dates and times and instances of when the sexual acts occurred. And so for that reason, I agree with Ms. Sharon. And she said that for that reason, she was going to grant the objection to OV 11. When she finished, I said to her, Your Honor, how are you ruling as it relates to the legality of the consecutive sentences? To which she responded, I'm sorry if I wasn't clear, but there is no authority for me to invoke consecutive sentences because of the lack of specificity. So this isn't an error that the trial court imputed from OV 11 to the consecutive sentences. The record is very clear of what the trial court found. And lastly, also, I'm sorry, this mention of the Dr. Gerton's report being a business record. This is not before the court today. It wasn't raised in the brief on appeal. And finally, if you look at Dr. Gerton's report, which the court has, you'll see that, again, there is no specificity. It is a general question to the child. Did anything ever happen with fingers? Yes. There's no follow-up question, nothing about date, place, or time. Your Honor, the trial court's rulings on the sentencing issues should be affirmed, and Mr. Birch's convictions should be vacated due to the deficient performance. Thank you very much.
I thought the business record issue was raised somewhere along the line. I see it in my notes.
In the brief on appeal?
Yeah, someplace. I read it someplace in the record.
Yeah, I think it's in there, Counsel. But you know,
That's all right. I mean, I just want to make sure that I've read correctly.
No, then if that's the case, I looked at the briefs again yesterday when I was preparing. I believe that the argument was that it was admissible under 8034, which is the medical statement exception.
That's in there too. I know that.
Right.
So,
and the trial court, my understanding, the trial court decided it was not admissible under 8034.
Correct.
Did not address a business records exception.
I don't remember the business record exception being raised in the trial court because I raised the objection as to 8034, and I don't believe the prosecution ever argued that the business record exception applied, although I would certainly argue that it doesn't, but I don't think that's before the court today. I simply argued that 8034 didn't apply for the variety of reasons I've already discussed. I'm not going to.
We'll make sure we dig through the record
Okay.
and see it if it's there.
you're a good attorney. You got me thinking now.
Thank you, Your Honors.
Your Honor's one, it was on page 14 and page 15 of the brief.
Thanks. We'll take a look. Okay. Well argued, both of you. Thank you very much. This
Thanks.
case will be submitted. And we will move on to docket number 3, item number 3, docket number 376396, People versus Raymond Lewis Treadway. I believe we have one person on remote and one person here. So Ms. Lebrecq, if you will just give us a moment while opposing counsel comes up to the table.
Sure.
All right. Good morning. Ms. Lebrecq, please go ahead.
Thank you, Your Honors. Appearing before the court is Attorney Ann Lebrecq, appearing on behalf of the defendant. Essentially, Your Honors, I'm more interested in whether or not you have any questions for me. I realize you have read the briefs. I think both sides have argued fairly well. Unless you have any questions for me, I plan on resting on my brief as it is.
Okay. Thank you very much.
Thank you.
Good morning. May it please the court, Matt Wade, Jackson County Prosecutor's Office on behalf of the people. I too would just simply rest on my briefs and happy to answer any questions the court may have.
Thank you both.
Thank you very
We
much.
appreciate it.
Thank
That
you.
case will be submitted. Have a good morning. Moving on to the next item, it's item number 4, docket number 374107, People versus Scott Weston Esch. And I believe we have Mr. Simon remote. Good morning, Mr. Simon.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Esch. Your Honors, I too would pretty much rest on my brief. We believe that for the reasons set forth in argument 2, Mr. Esch did not receive a fair trial based upon all of the, I think, irrelevant and highly prejudicial comments which were admitted regarding Kyle Rittenhouse and the use of the N-word. We also believe that in the alternative, he should be resentenced based upon the scoring of offense variables 1 and 2.
Any questions? Oh, okay. Good morning.
May it please the court, Jerry Scrutenborg, Ingham County Assistant Prosecutor for Plaintiff Appellee. Well, the thing about Kyle Rittenhouse, that was properly let in because it tended to show his state of mind, as the cases have said. The thing about the N-word, which was not repeated at any time whatsoever, and there was no specific objection to that. The objection was the other thing. There's no plain error here. The thing about OVs 1 and 2, well, we have a Supreme Court case dead on point that says that it's proper. So I ask the court to affirm.
Good. You, I think. Okay. Mr. Simon, any rebuttal?
No, Your Honor.
Okay. Well, thank you both very much. That case will be submitted, and have a good morning.
Thank you.
All right. Moving on to item number 5, docket number 374765, People versus Dondre Marquise Bell. Good morning.
Sorry, I'm not going to be quite as brief as those before me. And I think Judge Riordan has probably heard a few of these arguments from me before because I've argued on this exact issue a couple of times.
And
now.
I think 2 of us on this panel signed your order or voted on your order for leave to appeal. I signed it.
Great. Okay. So I'll be sort of reiterating what you've heard before, but I think it's
We
a
read
really,
a lot about this case, so.
I think it's a very fuzzy issue in our state right now, and courts, at least in my limited experience, I've seen courts handle it very differently, even within circuits. So
That's why we granted leave to appeal.
great. Okay. So the easiest way to frame the issue in this case is to consider a hypothetical.
Counsel, just to be clear, I see a couple issues here. Are you talking about the jail credit issue?
Yes.
Okay.
Yes. Okay. So let's take an example. If defendant commits a crime on January 1st in 2 counties, Oakland and Ingham, he's arrested in Ingham and bond is denied on both cases that same day. He proceeds along and the Oakland case gets resolved really quickly, let's say within a year. And then it takes quite a bit longer on the other case, let's say 3 years. Under the way that our courts are administering the jail credit statute now, his credit would cut off for the other case on the time when he is sentenced in the Oakland case. And that's really not what the jail credit says. So if you look at the statute, it says once bond is denied, defendant is incarcerated on that case, awaiting sentence, and should get credit in both cases. It shouldn't matter actually when he is sentenced. So as we know, this is a statute that's to be construed liberally and as written.
Our cases didn't happen on the same day.
Correct.
We have one, I think it's June 21st, 2022, and the other on October 4th, 2022.
Right.
So they're 2 separate cases.
They are.
You can't say they're part of the same crime spree or what have you.
Right. But it really shouldn't matter if defendant is detained on 2 or more offenses arising out of the same case or 2 or more offenses arising out of different transactions. And we have to look at the case law that we have. I mean, we have cases like Iziak that talk about where it's appropriate to delay the start of the jail credit because there's a statute specifically on point that says you shouldn't do that in a situation where there's parole. That if you're in on a parole violation, you actually cut off the jail credit. And that's why the case is decided that way. And if you look at Prescorn, that case is where he was following the first sentence. He was then subsequently he was released on bond in the first sentence and then was subsequently arrested for something else and incarcerated on that something else, the subsequent sentence, and tried to get credit on the first case. That's not what we have here. We have a case where defendant was incarcerated on his first case and then later tried to get sentence credit on the second case.
And counsel, what about, I don't know if it's Given or Given.
Givens,
I guess
right?
what I would like to know from you is just, you know, I think I understand your interpretive argument and the reasoning
Right.
underlying it, but you know, what sort of, candidly, you know, what sort of, you know, precedential brush would need to be cleared for you to prevail on that at this point between published authority from our court and
Right.
obviously from our Supreme Court?
Right. And I think maybe it might be the Supreme Court that would end up having to resolve it because I think the Givens court actually misinterpreted Prescorn and said that defendant can never get sentence credit if he's sentenced and is incarcerated on another
Given
case.
factually, you know, given the case, factually is, do you agree that it's, you know, roughly on all fours here?
It's
And
similar.
just kind of
It's similar, but if you actually read what Justice Levin said in his concurrence, he indicates that without regard to whether there is more than one reason that explains the jail credit, if there's more than one reason that the justice system is delaying him and keeping him incarcerated, whatever period he was so incarcerated on that, he should be entitled to credit. I mean, Prescorn really dealt with when a first case and he gets released out on bond and then does something else. That's not what happened in Givens. Givens really misinterpreted the law. And then if you look at other cases that have come out of this court, like Chandler, where it's very similar to my situation, in that, I mean, the defendant actually posted bond there, but then once he was incarcerated on the other case, his lawyer went in and revoked that bond, and the court gave him credit because the bond was revoked, even though he was actually incarcerated for another case. So I think there's a lot of disparity in the way that courts are handling this. I mean, and if you look at the Adkins case, which is another case that was decided around the same time as Prescorn, it left open the possibility for the judges to grant sentence credit by way of a minimum sentence reduction. So some courts are getting around it by doing that. And we have courts applying Chandler, we have courts applying the Adkins discretion, and there's really no consistency at all within the courts. And that's part of the problem here, is that it's not being done fairly, and it's a due process violation for these defendants depending on where they're sentenced.
In this case, the first sentence was arose from a revocation of probation.
Correct.
Is that right? Did the revocation occur because of the offense conduct of the second case?
Yes.
Okay, so I know it's not the same as a parole detainer or parole revocation, but there is a factual link between the two cases. Not in the sense that the original conduct was linked, but that the revocation of probation,
Right.
which gave rise to the resentencing, was linked. Is that right?
It's right, but in that case, we have a statute that actually says, no, you shouldn't be doing that. And that's been promulgated by the legislature. We don't have such a
You mean
statute.
in parole land.
Correct.
Right, and in
Correct.
here, we're not
We
in
don't
parole
have
land.
such a statute.
So-
Exactly. Any other questions? It's a tricky area, and that's the problem, is it is applied so differently. I mean, I'm aware of a number of cases that are pending now on this exact issue, and I just think we need some clarity, whether it be one way or the other. Thank you.
Thanks very much.
May it please the court, Jerry Scrotenbor, Ingham County Assistant Prosecutor for Plaintiff Appellee. Well, there actually is a case that dealt with credit for time served on a probation revocation based on the new charge. People versus Heim, cited in my brief. Defendant got probation on the first one. Then he got arrested on the second one. So on the first one, he received 30 days jail time for a probation violation. Then when he got sentenced on the second, the judge gave him credit for time served. Then the evil prosecutor in that case cross-appealed, asking the court to take away the credit for time served. The court affirmed on the defendant's appeal and reversed on the prosecutor's appeal and said, defendant gets no credit for that time. Heim came out in 1994, and in other words, it's binding on this court. In fact, if you take a look at defendant's analysis, he is essentially asking to overrule Atkins, Heim, Givens, and even Priscorn, basically saying, all you have to do is just ask to revoke bond. That's all you have to do, because then you're in, because you can't make bond. And then you get credit in absolutely every case. Oh, if counsel didn't ask for it, oh, then it's ineffective assistance of counsel. So therefore, it's credit in every last single case. Now, to the extent that there is a difference in the courts in this state, it comes down to a difference based on following the law. I went into Bay County a few years ago, and I discovered they were giving credit for pretty much everything. After a number of months there, all of a sudden, they stopped giving credit when I started pointing out what the law is. Yeah, the defense lawyers were very upset with that, but the judges said, no, that's what the law is. They even went to my boss. And my boss said, we're just following the law. And that's what we have here. Nothing but the law. So, and the thing about the Atkins footnote, yes, defendant is correctly interpreting. Yes, in fact, a judge who thinks it's unfair may reduce the minimum. That is perfectly within his ability. Back in Jackson, I had a resentencing and I said, no, you can't give credit for time served for those 2 weeks. So the judge said, okay, fine. I'm reducing the minimum sentence by 1 month. Yeah, I know. He followed the law. He had the right to do that. And that's what I'm asking this court to do, to follow the law. Heim and Givens and Atkins are dead on point. They mandate that this court affirm.
But counsel, let me ask you a question just in terms of, the last point you made in terms of how a judge can account for the lack of discretion on the jail credit side.
Yeah.
Here, am I right that that the sentencing happened pursuant to a COPS agreement?
Yeah, I think so.
So how does that layer on? I guess if it were the case that, the judge here said, okay, I recognize I don't have a path for jail credit, but I think there should be less. How would that interact with the COPS situation?
Well, that would be the agreement between the parties. The parties would know what the law is, presumably, and it would work out in such a situation that, okay, this is what the sentence is, knowing he won't get credit from this date on. And the huge delay, well, the Waklowski case dealt with that, said that's irrelevant. Of course, the whole point of concurrent consecutive, yeah, Priscorn itself said that's irrelevant. So that's how that comes up in a sentence bargain situation. We've already taken that into account.
But you could have a situation, obviously, where you enter the pleas entered, the agreement's entered, then there's a delay until sentencing, and you kind of realize you get there and you're saying, hey, this sentence we agreed to, maybe at that point, the judge is thinking there's some adjustment that needs to be made here. Do we need to go through sort of the Cobb's,
Well, if the prosecutor,
undo the whole agreement? How does that?
okay, if the prosecutor has no problem with that, fine. That takes care of that. If the prosecutor has a problem with that, if the judge refuses to follow, the prosecutor has the right to withdraw the plea and then go to trial. And of course, the defendant, as we know, will get a much higher sentence. So yes,
Okay, understood.
yes.
Just briefly.
Sure.
I mean, I think what's important here is to look at price scoring and the reason the sentence was handed down like that. Where a defendant is actually released on bond arising from one offense, then goes out, commits the second offense, and is subsequently incarcerated on that second offense, the first offense isn't the reason he was incarcerated. In these cases where somebody is incarcerated and doesn't receive bond on the subsequent offense, that's the reason they're actually incarcerated. I mean, there's nothing in the history, purpose, or language of the jail credit statute that says there should be a distinction here. It says credit should be granted. So I would argue that that is what should have decided Givens, and that case is actually wrong. And, for brother counsel to say, well, it's just up to the judge if they want to reduce the minimum sentence, that just is so much arbitrary and unfair justice that's being doled out depending on what the court actually wants to do. And my client is a very specific example. On this case, he went to prison. He had actually finished his other sentence before he was actually sentenced on this case. So he sat there in prison waiting to be sentenced on this new case, but obviously they wouldn't release him because he had the new case pending. So it needs further clarity in the law to come out from either a conflict panel or a Michigan Supreme Court case to make it more clear so people are treated fairly. Thank you.
Thanks very much. Thank you both. That case will be submitted. Have a good morning. Before we move on to the next cases, we're going to take a quick break. We'll be back shortly. Thank you.
Nine 565 Detroit Public Schools Community District versus Department of Treasury.
Good morning, Your Honors. Morning. May it please the court, Scott Eldridge from Miller Canfield on behalf of the plaintiffs, and with me at counsel's table is my colleague, also from Miller Canfield, Emily Barr. I'd like to reserve 3 minutes for rebuttal.
Sure, we try to ask you to keep your own time, but that's fine.
Thank you, Your Honor. In 2016, the legislature formulated a specific plan aimed directly at getting Detroit Public Schools, also known as the Old District, out from under its mounting and insurmountable debt that had accumulated over a number of years, and telling DPS exactly how it should go about repaying its debt. And that is by using all of the tax levy tools available. Now, the legislature effectuated this solution for DPS in a specific set and series of statutes and bills that they passed in 2016, all simplifying the complexities of the various statutes that are at play, including, to name a few, the Revised School Code, the Trust Fund Act, and the School Bond Qualification Act. Now, the two most important and relevant statutes at play today, in this case, are Section 12B of the Revised School Code, which is MCL 380.12B, and Section 386 of the Revised School Code, MCL 380.386. Section 12B, of course, is the directive to DPS to pay back all of its debt, and it defined debt exceedingly broadly to include any monetary obligation. And it told DPS exactly what mechanism to use, in part, to pay back all of that debt as defined in the statute. And that mechanism is an operating tax that can be levied under Section 1211 of the revised school code.
But counsel, just to be clear, I don't think anybody disputes that the operating tax can be used with respect to some of the debt, right? The difference is how much. Is that accurate? You're saying that the operating tax is the mechanism that is used for all the debt.
Correct. It can be used for all
I
of the debt.
understand Treasurer's position is that there's a limit. It's actually just for, a certain portion of the debt.
Correct. And the position of our friends on the other side requires this court to read words into 12B that just don't exist. And if we look at 12B in particular, subsection 3, subparens B, this is where the legislature has directed DPS to use various tools to pay off all debt. And remember, debt is defined so broadly that it obviously encompasses bond debt and the revolving fund debt that's at issue. And the court said in subparens B that DPS must do, quote, all other things relative to the repayment of outstanding debt. And then it goes on to say, including but not limited to.
Well, counsel, you skipped some words. Required by law and by the terms of the debt. So I guess is your argument that the law, the law otherwise authorizes the use of the operating tax to pay down all the debt? Or is your argument that this provision provides a new and additional grant of authority that doesn't otherwise exist?
We think it can be read both ways. Our first argument is that we'll start and end with 12B. 12B says debt. Debt is a defined term. It doesn't say debt as limited by 1211. It doesn't say debt or some other term. It would require us to replace the word debt with school operating purposes to accept their argument. We still think we win under an examination of what it means to be a school operating purpose for the reasons stated in our brief, and I'm happy to address that. We still think we win there too.
That's 1211.
That's
So we
1211.
look there to say that's where the pre-existing authority would be if we didn't have this provision.
Correct, and that's because the revised school code requires us as a school district to pledge operating tax in the general fund, which is derived from the operating tax, to pledge it to repay bonds, which are at issue, the capital improvement bonds that are at issue. So we think we win under that argument too. And we're obligated to pledge it. So if we're obligated to pledge our general funds, which is derived from the operating tax, clearly we have the ability to spend the general funds derived from the operating tax to repay that debt as part of the school operating purposes. But again, we don't think you need to even get to the school operating purposes analysis because 12B is so explicit about paying off debt. If the legislature wanted to limit that in any way, they could have, and they didn't. They said the mechanism by which you are to repay all of this debt, and the definition of debt includes a reference to the Municipal Finance Act, which expressly includes bonds in the definition of debt. So there's a cross-reference there to bonds explicitly. If though the court wanted to limit that, or I'm sorry, the legislature wanted to limit that in some way, they could have done that and they just didn't do it. And again, this was done specifically for DPS to get it out from under the debt as quickly as possible so we could dissolve it. And then all of the assets can be transferred to the new district. And by allowing the DPS to use its operational tax to pay off that debt achieves that goal. And that's why the legislature wrote the legislation the way it did.
Isn't there a requirement, and maybe you're saying this is superseded somehow by 12B, but isn't there a requirement that when you collect a tax, you collect it for a certain purpose, and on the ballot or as part of the millage, the voters who are voting on that know what it's going to be used for?
Yes.
And seems, I think, that this millage went to the voters as an operating tax.
It did, Your Honor, in 2024. It was renewed in 2024 until 2033.
Right.
And
So-
the
so-
resolution and the actual language of the ballot specifically said that this would, quote, would allow the school district to continue to retire its debt obligations, end quote. It told
But it
the
also-
people exactly what they were using it for, and it was to pay off debt,
Well,
which is
but-
what
but it
school
had
districts
debt-
do all the time.
It had debt on school, it had school operating, right? It had two kinds of debt. And didn't the ballot proposal say that this is for school operating purposes?
It said, quote, which would allow the school district to continue to retire its debt obligations, end quote. It is
Nothing about school operating?
It specifically, it specifically referenced the opportunity to repay debt. So the people were on notice that this was going to be used to repay debt, and that's how schools operate. The Court of Appeals the Court of Claims in this case, Your Honors, issued a decision that would kind of upend the general practices of all school districts around the state by saying you can't use operating tax to pay off bond debt. That's never been the case, and decades of practice within school districts would be completely upended if that decision or that part of the decision were left undisturbed. And again, these school districts have an obligation to pledge under section 1351 and 1351A of the revised school code, as we briefed, the district is obligated to pledge its general funds. That means it's obligated to use its operating funds to pay off bond debt. 1351 and 1351A are about incurring bond debt. So it is absolutely a school operating purpose to pay off bond debt that is used to run these schools. In my friends on the other side concede that school operating purposes, if we're looking to that definition for the resolution here, and again, we don't think you need to because of what 12B says, but our friends on the other side say, they seem to concede that it's not an exhaustive list of what's identified in the definition of school operating purposes under 1211. They concede that that schools regularly use it and can use it to pay salaries, pay for textbooks, things that aren't identified in that provision. But the operating in capital improvement bonds, that are at issue in this particular case, as we allege in the complaint, specifically were incurred, the bond debt was incurred for many of the reasons identified expressly in 1211. And there's nothing in the record that seems to contradict that allegation.
And everything that was used, that capital bond was used for, is everything captured within 1211, or are you just saying there were some?
Yeah, I can't make that representation to the court that everything was. But again, the more important piece under 1351 and 1351A is that we have a statutory obligation to pledge the general fund to be able to pay back these bonds. And we have now, because of that, the school district has a contractual obligation to the bond holders to use that general fund to pay back the bonds if they need to. Otherwise, it would be, and if the statute operates a different way, which is what the Court of Claims seems to think, that would effectuate an impairment of contracts in violation of the Michigan Constitution.
So I hear you on the issue of once you have funds, you're obligated to pay your debt, no matter what that debt is, with the funds that you already have. Isn't that a separate question from how you bring in the funds, right? You can't rob a bank to get the funds and then say, well, we have these funds and now we're obligated to pay our debts with them. And so isn't there a separate question of whether you can bring in the funds on using the school operating tax as opposed to the other tax?
I don't think there's any question about it, Your Honor, if that's what you're getting at. And that's because, again, of 1351 and 1351A. 1351, there are companion provisions in the revised school code. One deals with bond debt that's incurred before 1994. Another one, 1351A, deals with bond debt incurred after 1994. But they both incorporate the exact same language, and that is, this is subparents 4 of section 1351. It says, quote, bonds or notes issued by a school district or immediate school district under this part or section 442, 629, or 1274A shall be full faith and credit tax limited obligations of the district pledging the general funds, end quote. goes on after that, but that's the most important piece. So they have a statutory obligation and requirement to pledge those general funds, which again, the source of which is the operating tax. Operating tax and any school aid that may come their way from the state. But it absolutely includes the operating tax. So if you look at section, I'm sorry. Sorry, bear with me. My apologies. Section 1215 of the revised school code, which is MCL 380.1215, subparens 1 reads, quote, operating taxes shall be accounted for under the title of general fund, end quote. So that's for those reasons, Your Honor, we think even if we have to look at the definition of 1211, which we don't think is the appropriate analysis because 12B is this more specific statute related to the dissolution and repayment of debt by the DPS. Because the word debt is defined so broadly, the legislature, I'm sorry, made unequivocally clear how it is that the school district is to go about paying off that debt. And it said you're supposed to use the levying or seeking of voter approval for the renewal of school operating tax under section 1211. If my friends on the other side position is left to stand, it allows for, and is demonstrated as something we noted by something we noted in our briefing, allows for the arbitrary enforcement or interpretation of this depending on how much state dollars are at stake. And what I'm getting at is just a few years prior to this matter, the Treasury Department told Inkster Public Schools in almost an identical situation under language in section 12 of the revised school code, which is identical for is materially identical for purposes of the analysis, that they had to use their operating tax under 1211 to pay back their outstanding revolving fund debt. The exact opposite guidance and direction that Treasury is giving to DPS just a few years later. And there's been zero explanation as to why those two divergent determinations have been made.
I mean, it sounds like and I'm sure we'll hear from them about it, but it sounds like their explanation is that there is a material distinction between 12 and 12B.
Yeah, I don't.
And from your perspective, that's not there.
I don't see the difference. It uses the same language in terms of requiring the debt to be paid by levying and using an operating tax under 1211. It's like verbatim language in the two. And somehow that didn't apply or somehow meant something different for Inkster than it does for DPS. I think it has to do with the fact that the state is on the hook for fully funding the foundation allowance under the Trust Fund Act vis-a-vis DPS. And that's ultimately why we're here. The Treasury notified DPS that they were going to no longer, once the emergency loan was paid off, they've determined based on their own analysis, again, contrary to the Inkster case, that because they believe that DPS could not continue to use the operating tax to pay off the remaining debt, the bond debt and revolving fund debt, that the new district would have to seek voter approval and levy its own operating tax. I mentioned earlier that the other most relevant provision here is section 386. 386 of the revised school code says that the new district cannot levy its own operating tax under 1211 while DPS is authorized to levy its own operating tax under 1211. And our reading of 12B is, again, that it is mandatory obligation of DPS to levy this operating tax until it pays off all of that debt. That means the new district cannot levy its own operating tax until the debt is extinguished entirely of DPS and DPS dissolves.
So I guess for purposes of 380.286, which doesn't mention, for better or for worse, 12B. It's just if another school district is authorized to levy the operating tax under 1211. But it sounds like you're saying that we should, for purposes of this case, look to whether it's authorized under 12B, not 1211. Is that accurate?
That's the starting point, is our argument, that 12B answers the question.
Right, but I guess how do I reconcile that with the language of 286, which doesn't mention
I
12?
think Your Honor means 386.
Oh, that may be.
Yeah, 386 is the provision I was just referencing. Well, 386 was enacted as one of those companion bills along with the bill that became 12B. So they were all enacted at the same time.
But
So
I guess
the legislature,
does that help or hurt your argument about that we should be looking to what's authorized under 12B rather than 1211?
well, I don't think it necessarily answers that question. I don't think 386 answers that question. All 386 does, and why it's so important in the case, is it just simply says that the new district cannot do what Treasury is saying it needs to start doing. In the governor's recent proposed appropriation bill, they excluded the foundation allowance funding for DPS. I'm sorry, for the new district in this next fiscal budget. We think that's wrong. We think they have to continue funding that allowance for as long as DPS is levying its own operating tax, which 12B says they have to do until all the debt is repaid.
So
The new district cannot start levying its own operating tax as a matter of law.
So in 12B, what is your theory for why the legislature created this division in terms of notifying the state treasurer upon repayment of all outstanding operating obligations, and then a separate provision for separate time when you notify the state treasurer upon the repayment of all outstanding debt, right? There's this distinction. And then, I mean, I know they're arguing that that means a lot. And I took it from your brief, you're arguing it means nothing. And I'm trying to figure out, well, why would they create that distinction in the statute? What's the story there?
That's it. Thank you for the question, Your Honor. I don't think we have a theory. I'm just reading the words of the statute. And the words of the statute say, yes, there's two notice points in time that occur. One is simply just a notice, and that's the first notification obligation of Treasury, which is to notify the school district under Section 12, subpart 12 of 12B, that the operating obligations have been satisfied. Period. Hard stop. End of story. It's just a notice obligation. There's nothing in the
No
statute.
policy behind it. There's no reason for it.
Well, it's not stated in the statute that there's an obligation to do anything else, or that notice then triggers some other event.
It doesn't explicitly say that.
No.
I agree. But I think we're trying to figure out, is this like random words on a piece of paper, or was there a reason why there would be an interest in dividing these two notifications up?
Well, if it certainly doesn't mean what my friends on the other side say it means, that it means now there's some kind of, I think they say it means that there's an automatic transfer of this obligation to the new district to start levying an operating tax. That would require a very meaningful and significant rewrite of the statute. The legislature could have said all of that if it wanted to. It didn't. It just said it's a notice obligation. I don't think we presume that the legislature is just putting words on in a statute just for fun, but that doesn't mean they had any more intent than what is in the plain words of the statute. That's where we start. Intent of the legislature is we start with the plain words. We can't start inserting language that isn't there to say, well, they must have meant then somehow that that point in time we're transferring this obligation to start levying a new tax over to the new district. That's especially true when, in our view, 12B says we have to continue levying it and utilizing it to pay off all debt. That's the word used in 12B, subparens 3, subparens B, which is defined. Because of that, that notice provision can't be read to mean it had to mean something else other than what 12B, subparens 3, subparens B meant. So we don't really have a theory, Your Honor, so much as we're just reading the plain words of the statute. Now contrast that with subparens 13 of 12B, which is the second notice obligation. The second is that if the state treasurer is notified that all outstanding debt is then paid, right, then it triggers the next step, which is referenced in subparents 14, that upon that certification and notice under 13, the qualifying school district is fully dissolved and any remaining assets of the qualifying school district are then transferred to the community district. So the legislature made it very clear that the first notice is just a notice obligation. The second notice is another notice obligation, but that second notice obligation then triggers that final step of dissolving and transferring assets.
I mean, I'll be honest with you, and I'm only speaking for myself. It would be a lot easier to accept your overall case if you had a theory for why that first notice was there. And so far, our only, and I mean, you know, I'm just being honest, so far, our only explanation is, well, it's just a notice statute. But it just seems a little fishy to me that they would write that in there, but that wouldn't be at least some sort of circumstantial evidence that they wanted something to change after that first notice.
I just don't see it in the statute anywhere else in the statute that would suggest circumstantial evidence. And I think we'd be injecting into the statute words or intent that's just not there.
I guess, Counsel,
it could be.
I'm sorry, go.
Thank you. I mean, it could be just as simple as making sure everybody's on the same page that these operating obligations have been paid off and that we're progressing towards the dissolution, which is then, you know, triggered by the final payoff of all of the debt. When that's that second notice obligation, it could be as simple as that.
And I guess the way I am understanding, I guess, opposing counsel's theory, it's not necessarily strictly at odds with that it's just that the legal effects that may attend paying off the operating debt, those are kind of operationalized through other statutes. And this notice obligation is providing notice that, hey, we've hit this point. And then once you hit that point, there are these other statutes that, you know, are going to start becoming relevant. And perhaps that's why you don't necessarily have a consequence directly written into 12B, because those consequences are, you know, extant in other parts of the law. So I guess I'm curious, you know, what your thoughts are on that.
Well, yeah, again, all we can do is look at to the plain language of the statute. But again, it might, again, just be as simple as, yes, you have all these there's these operating obligations that need to be taken care of. That's a box that needs to be checked. And we're all certifying through this notification process in subparents 12 that, yes, we all agree that those boxes have been checked. Now let's move on to the rest of the debt, which is 13. The rest of the debt is what triggers then ultimately the dissolution. And I think it seems to me to be as simple as that. And I think it would be a dangerous ground for the court to start injecting more intent into the statute than what's on the in the plain words of the statute.
Is at the beginning of the argument, we talked about the millage and the ballot proposal that went to the voters. Is that in the record? Do you have any idea?
I don't know if it's in the
I was
record.
just looking for that. You really don't argue it in your brief either.
It's not highlighted in our briefing. It is a matter of public record.
It's a matter of public record. We can find it ourselves.
Correct. And we
It's-
could certainly
I find it interesting that you're kind of hanging your hat on that.
Well, it's just one other point. I think it was in response to a question that I received about, and I think it was alluding to an argument my friends on their side are making about how there's different tax bases.
I'm going to ask them about the ballot.
Yeah, but there's no violation of the statute that they cite here, because the ballot proposal at issue was clear that it was going to be
When you're
used to
talking
pay
about
off
the
debt.
ballot proposal language, are you talking about the summary? Or are you talking about the entire text of the proposal?
Yeah, it's in the text of the proposal.
Was there a summary of the proposal?
Well, so
Tax proposal.
oftentimes there's like a whereas, you know, some preamble language that's not necessary under the statute to put in there, but the actual proposal, which is the question posed to the electorate, is the one I quoted to you earlier, Your Honor, about, I mean, it does use the word operating purposes. It says, this proposal would restore and increase the limitation on the amount of taxes which may be levied by the school district for general operating purposes, which would allow the school district to continue to retire its debt obligations.
And that's the sum total of the ballot proposal.
No, I mean, there's some other words in there that I did skip over that I didn't feel were terribly
we'll have to
important.
take a look at that.
Was it
Happy to
proposal-
quote it.
Was this proposal S? Is that right?
Pardon?
Was this proposal S as in
Oh,
Sam?
I don't know
not
that.
sure.
I don't know that, Your Honor. I don't know the answer to that particular question, but it was the 2024 renewal
Okay.
proposal.
All right, if you want some time for rebuttal,
Yes.
now's the time
Yeah,
to
thank you.
reserve it.
Thank
So
you. I
thanks.
appreciate your time.
Okay.
Good morning, Your Honors. I should say, well, no, it's still morning. Good morning. Assistant Attorney General David Thompson here on behalf of Treasury, and with me at counsel's table is Assistant Attorney General Justin Call. Your Honors, I'd like to kind of go through a number of points, and I'll try to keep it as brief as I can. The governing law and the indenture agreement in this case make clear that DPS can't use the operating millage to pay for capital expenditures and other legacy debts. And this was always the plan since 2016 when there was a second district created. Since then, the state has sent nearly $900 million to DPS to help it pay down its debts while allowing DPS to divert its operating millage to pay down
What's going
these.
to happen to the new DPSC finances if this funding mechanism is discontinued?
Your Honor, at that point, so the levy authorization for the operating millage switches from the old district to the new district, right? And any remaining funds in the trust fund per the indenture agreement,
They go over to the new
they go over to
district
the new
again.
district. That's
All
correct.
right, will there be another funding mechanism or will there be another ballot proposal?
So
Speculating.
there would have to be, so that operating millage has to have approval by the voter, so that has to be voted on. But in the meantime, the old district DPS maintains its authorization to levy the 13 mil debt millage, that's 1351A, with the state's guarantee in the state loan revolving fund program, right? So any overage above what their proceeds can capture from that 13 millage, the state is a continuing partner with old district on that millage. So those debts will continue to get paid. But in terms of the going concern, the operating district, that's the new district. So they're the ones who would have the authorization to levy subject to a vote of the approval of the voters.
Okay.
So this is how it has been contemplated now as then. And what they want is a nearly $2 billion continuing obligation and foundation allowance backfill going forward to something like 2040. I think the dates maybe are not altogether clear, but to be clear, that's something that the state never agreed to back in 2016, right? We were going to stay on the hook for the foundation allowance backfill only for purposes of these operating obligations, right? And the $150 million state emergency loan, right? That was for transitional costs to move from old co to new co. And I'm saying that old district to new district to be clear with the language. That was a very specific carve out, right? Where we would allow the operating millage to cover that piece as well. Your Honors, you had questions about the terms of the debt. And I want to make clear there's a number of distinctions here that I think are getting missed in opposing counsel's presentation. So we know about the 18 millage or the 18 mil operating millage, right? There's also two forms of bonded debt. There's the 1351 debt and there's also 1351A debt. And I know all this stuff gets kind of complex, but the short story is the 1351 debt does not come with the state's guarantee. It doesn't come with strings attached. The 1351A debt does come with the state's guarantee, and it does come with strings attached. DPS is in a unique scenario where they are operating under the latter. They have the state's guarantee, they have those strings attached. And so in terms of this 12B provision, what it's empowering DPS to do is to pay back, right? And I agree with brother counsel. He points you to 12B, 3B, right? And it talks about those two parts. It talks about drawing and borrowing from the revolving loan fund for debt service on qualified bonds under the State Bond Qualification Approval and Loan Act. Your Honors, I'm just going to say SBQAL, if that makes sense. And then, of course, there's the second piece, which is the 1211 levy for operating expenditures, right? So there are different terms of the debt. right? And to go to your question, Judge Karabkin, right, there's a question of what would the voters expect here? So certain properties are responsible for certain millages. For example, the non-homestead is responsible for the operating. And if you're a non-homestead taxpayer and you're paying your $100 per the 18 mill levy, you're expecting those dollars to go to things like teacher salaries, to operating expenses, the things that are actually incurred, right? Present progressive tense being incurred in the course of operating the school and teaching those kids. Would you be surprised to learn, right, as a voter, that the $100 that you paid thinking it was going to school supplies, teacher salaries and the like, was in fact going to other legacy debts, say retiree debts, right? Those frozen in time debts, would you be surprised to know? And I think you would, right? Because that's a voting.
Going beyond surprise, is there an actual law that says that they can't use the money they raise through operating taxes to pay down other debts?
We think there is, Your Honor. I think if you look
What
at
law is that?
I think if you look at section 1211, it talks about what that millage is for, right? It's for operating obligations. If you look at the revised school code, if you look in that 12B provision, 12B 15B also talks about operating obligations, and these are distinct, right? So you've got, again, the 1211 levy, you've got the 1351 levy, which really isn't an issue here, except as a point of distinction. And then you have that 1351A levy as well. So there really are different terms of the debt, and you have to understand, right, how these work. And for example, when it comes to the 1351A levy, and again, I know this all gets kind of complex, that 1351A levy comes with a 13 mil cap. That cap, that 13 mils, is both a statutory and a constitutional cap. The statutory cap comes from the SBQAL. The constitutional cap comes from Article 9, Section 16, right? That 13 mils, you can't levy more than 13 mils to pay down these types of debts. If you have a debt millage, if it's guaranteed by the state, if it has to comply, you have voter approval, right? Comply with the revised school code, et cetera. If you adopt their argument that you can dedicate proceeds from an 18 mil operating millage to these other forms of debt, what you've effectively done is you've negated, right? You've written out that cap, not only out of the SBQAL statutory provision, but also out of Michigan's constitution, because now you're allowing them to effectively levy 31 mils towards all of these other legacy debts.
Probably would have been helpful for your argument if the legislature had added a sentence that said the school district shall not use any of the money that it got from this tax to pay these other debts. And I take it from what you've said so far is that sentence cannot be found in the code.
Your Honor, I don't think it needs to be there. I think, so what you have a 12B, which we're kind of thinking of as like a quarterback provision, right? It's your wheel and spoke. And what it does is it points Detroit Public Schools to all the substantive provisions that surround it, right? These are the powers that you can exercise. You can exercise an operating levy authorization under 1211. You can exercise here, right? Draw requests and borrowing from the revolving loan fund for debt service on qualified bonds under the SBQAL. So they're being given a very delineated set of powers, and they're being pointed to the substantive provisions in the revised school code, as well as the Trust Fund Act and the SBQAL, right, where exercise of those powers is done, right, is properly done. So I think when we're talking about the bond debt, we have to acknowledge that there's different types of debts. You've got the 1351A that has the state's guarantee, that has those strings attached, and then you've got other forms as well. With respect to this question of the pledge, it was represented to you a number of times about we are required to pledge our general funds. There's a couple problems with this notion, Your Honors. So first, a pledge is not an authorization to levy. The authority to levy comes out of those substantive provisions, 1211, 1351, 1351A. So just because you have the power to pledge general funds towards certain types of debts, that's emphatically not an authorization to levy. Those are found in the substantive provisions.
I mean, can you pledge stuff that you don't have the authority to make good on?
Your Honor, that's the exact question I was just about to address. So the problem here is that every dollar that DPS generates from these millages is already spoken for. So they're talking about a general fund, right? That they can take operating millage proceeds and put it into their general fund. The problem with that is that there shouldn't be a general fund. Those operating millage monies go to a trustee who is charged with paying down debts pursuant to a certain debt schedule that's set out in the indenture agreement, right? And the very last debt on that list is the $150 million emergency loan. So it's not like they just have this 18 mil levy authorization, they collect all the proceeds, and now they have a slush fund or a general fund. That's not how it works. It goes to a trustee who then pays down certain debts according to that schedule of debts.
The pledge is subject to the schedule.
The pledge is absolutely subject to not only a schedule, but also what those millages, the purposes to which those millages could be put. So all of those funds for the operating millage, those are already spoken for. DPS does not have debts that it is incurring in a present progressive tense way, right? They have a frozen in time debt profile, right? That profile, each dollar in that schedule is already spoken for, right? So they have that and they have to pay according to that. And in fact, it's actually the trustee. And then they have this 1351A debt millage with the state's guarantee. So a pledge is not an authorization to levy. The dollars are already spoken for. It's not like they just have random monies sitting around that they can send to other forms of debt. And to the extent that they are a participant in the SBQAL SLRF loan revolving fund program, they are subject to that 13 mil debt millage cap. They can't levy above 13 mils for that purpose, Your Honors. So the pledge is kind of a red herring. It's not really part of this case, and I just wanted to address that.
You said they can't millage above the 13 mils. That's for the bond debt?
That's for the bonded debt, which, yes.
Are you saying that if they used money from the school operating tax to pay the bond debt, they'd be essentially working, like circumventing that 13 mil limit?
That's absolutely correct, Your Honor.
Okay.
Yeah, so you'd have 18 mils from the operating millage, the section 1211 operating millage. You'd have the 13 mils from the 1351A debt millage with the state's guarantee. You'd put them together and that's 31 total mils that they are levying towards legacy debts.
School operating tax is coming from a different tax base than the.
That's absolutely correct. Absolutely correct, Your Honor.
So the tax base that's being told, hey, the 13 mil is the maximum you're going to have to pay is actually not being levied. The school I mean, there might be some overlap, but it's not the same group, right?
It's not the same group, Your Honor. And I think that's in part why we have all of these distinctions and why the revised school code and the Trust Fund Act and the SBQAL program, I think that's why they have all of these fine distinctions. And why? Because we have to be stewards of the dollars. We have to be stewards of the law. And most importantly, Your Honors, if we're talking about voter expectations, we have to be accountable to what those expectations are. When a voter votes, okay, yes, I am voting yes on this ballot initiative, this 18 mil operating levy, we have to be faithful to those dollars and make sure that they're put to the purposes that those voters intended to. Because again, they are different tax bases. And so voter expectation is a crucial part of this. And I think that that's all part and parcel of the law, right? The entire statutory scheme, including the constitutional provision and the indenture agreement, which the revised school code section 12B requires them to comply with that indenture agreement. This is a wraparound scheme to ensure fidelity across dollars, voter expectations, and ultimately the law. Your Honors, I want to just quickly address this question of the Inkster School District. It was noted these are different, 12 and 12B are different. There's a number of differences, both legally and factually. Legally, 12 is the operating provision for Inkster, 12B is the operating provision for Detroit Public Schools. DPS is in a very unique instance they had a significant amount of debt, right? And like I said, if we're still on the hook for the foundational allowance, we're talking about another close to 2 billion when we've already done about 900 million. The debt figures for Inkster were much, much smaller. The other key distinction is that unlike in Inkster, in Detroit Public Schools, you have basically an overlay of a brand new district over the old one. So you have two districts in the same geographic boundaries. In Inkster, it was different. They had far less debt and they basically broke up that school district into other surrounding debts or other districts who would then.
No longer a school district, Inkster, correct?
That's correct. It did see a dissolution and it was basically absorbed by the surrounding school districts.
It ceased to operate.
Ceased to operate. And that's another key distinction here, Your Honor. DPS, the old district, is not an operating district. Under the revised school code, the technical phrase is qualifying district. And by qualifying, what we really mean is dissolving. It's a dissolving district. So the difference between that and this, and the other question about, how is this going to impact other school districts around the state? Your Honor, the key distinction between this scenario and all of the other school districts in the state is that those are all other operating districts. They are all currently teaching kids.
They're not in financial distress either, most of them anyway.
That's correct, Your Honor. The distinction here is that this is a qualifying, which is to say a dissolving district.
Right.
The only purpose for its existence is to pay down debt. So the Inkster scenario is legally and factually distinct. And we have explained that a number of times, both informally and throughout this litigation. Your Honors, on the question of the notices that are sent, Judge Mariani, I thought that your expression of this was better than anything I could come up with. You said that this is operationalized through other statutes. And here we're talking about the first notice that goes from, right, the treasurer to the new district when the operating obligations are satisfied. That certainly signifies that there has been a change of circumstance, Your Honors. That change of circumstance is that the operating millage, the only reason you have an operating millage is if you have operating debts giving rise to that millage. If you don't have new incurring present progressive tense debts that you're incurring for operating purposes, you don't have any reason to have an operating millage. Once that $150 million loan is paid, there are no more operating obligations. And so that first notice is exactly that. It's to give notice to the new district. You are now effectively authorized. We talked a lot about that Section 386 prohibition on two districts levying an operating millage at the same time. That prohibition drops out the second that the old district, right, has no operating obligations. That prohibition drops out, and now the new district steps in and can levy the 18 mil operating millage. So, Your Honor, when you say that transfer is operationalized through other statutes, that's exactly correct. And that language does have to mean something. And that's effectively what it means. It means that there has been a change. I don't know that it's because of that 12B12 provision. It's not the first notice that makes it happen. It's the other statutes, again, being operation. It's through those other statutes that this happens, and that has to have meaning, Your Honors.
But we still haven't found what that one magic statute is, it seems to me.
I think we have, Your Honor. I think if you look at Section 1211 authorizes a levy for operating millage, an operating millage, so long as there's operating obligations. When there's no longer operating obligations, the 1211 levy authorization drops out. That trips the Trust Fund Act, right? And it also trips that 386 provision, right, that says you can't have two operating millages at once. Well, now you don't have the second one. So NewCo, the new district, now has that authorization. So that's the meaning of the first notice. And Your Honor, I don't have anything more eloquent than I could add than what you had indicated.
Can you, so I know it's pretty clear that the emergency loan debt is considered an operating obligation because the statute says so. But I guess, how do I know that none of the other debt, none of it at all, it may fall within that bucket too? And, because it seems like we're dividing things up, by, we have these bonds and the revolving fund loans for the debt service. Definitely, categorically not. Emergency loan categorically is. So I can see why the emergency loan categorically is, because the statute tells me that. But how do I know that all of the rest of the debt, even if I agree that, you can, if you looked at kind of what it was incurred for and how it was used, would not be an operating cost? Like, why is it not possible for it to be some of both?
Your Honor, I think if we look at those enabling authorization sections, the substantive provisions, I think they help to answer this question. For example, section 1211, monies raised by the tax shall not be used for a purpose other than that for which it was raised, right? Without the consent of a majority of the school electors. We're talking about if there is a levy an authorization to levy under 1211, we are constricted to the purposes of that 1211 authorization, right? And of course, we have the definition of operating obligations. We've got the same thing in section 12B as well. And then you have the 13 mil cap, right, based on the debt millage, right? And that's for very specific capital and legacy and other forms of debt. So I think those substantive provisions answer these questions. And 12B is not overriding those. 12B is just saying, DPS, your job is to pay down debt, but when you do it, you have to do it in accordance with all of these other governing substantive provisions and the indenture agreement, right? And all of that, of course, is again then subject to Michigan's Constitution, which has that 13 mil cap on the debt millage for 1351A debts, right? So I think they're there in the substantive provisions.
And does any of this go back to what we were discussing before about the ballot proposal?
Your Honor, I think it does. I think we have to be faithful to voter expectations. And certainly as opposing counsel mentioned, right?
You said we don't have that in the record. Is that right?
Your Honor, I believe that the ballot language is in the record. I'd be happy to prepare a supplemental brief on that if it's a question that's bothering you, but
I think that would be helpful.
Okay. Opposing counsel indicated that this is general operating purposes. So even the language of the ballot itself gave indication explicitly to voters exactly what it was that they were voting on, right? It's general operating obligations. DPS's situation, again, it's a frozen in time debt profile. All of its debts are past tense incurred debts. So I do think it goes back to that. And I think ultimately that's why we have the statutory provisions that we do. I think that's why we have the constitutional limitations that we do. So what you effectively have here, Your Honors, you've got section 12B in conjunction with the SBQAL, which again describes these different forms of debt, including unlimited voter approved qualified bonds, which relate to capital expenditures. And that again is a constitutional concept. The statute and the indenture agreement are effectively this wraparound scheme that contemplates that the operating levy will be used to pay down those debts that had been incurred by the now frozen in time DPS. And that once those debts are paid, the only thing remaining, which is the balance of that $150 million loan, which should be paid by September of this year, then the authorization, right, for that operating millage transfers to the community district. It can't be that they're able to circumvent that 13 mil debt millage cap and effectively levy upwards of 31 mils towards legacy debts. Your Honors, this is a plain text reading. It is faithful to the intent of the legislature. It is accountable to the dollars, and it is accountable to the voters who are responsible to pay for these millages. If there are no further questions, we just ask that you affirm the court of claims. Thank you very much for your time.
Mr. Elders?
What's he have, 3 minutes?
3 minutes.
Thank you, Your Honor. My friend on the other side and I agree on one thing, and these various statutes are complex, and there's a lot of them facing with one another. But this is, we think, why 12B is the starting and ending point ultimately for your analysis. What the legislature did is said, yes, all of this is complex, but for purposes of DPS in 2016, starting 2016, we're going to simplify this. You're going to be able to use all of these tax levy tools available to you, including the operating tax under 1211, to pay off all debt unmistakably. And so this was the intent of the legislature, to move away from all of that complexity for purposes of dissolving DPS. I want to address a couple of items. First, Your Honor, you asked if this was proposal S. The answer is yes, confirmed by my colleague.
Thank you.
Council
That's
table. Regarding the council referenced the indenture agreement, and I wanted just to raise a point in response to Your Honor's question about these two different notice provisions. I think the indenture agreement might glean some additional light on what that first notice obligation was designed to do. The master indenture places a lien on the operating tax revenue so that it must be used to first be to pay the operating obligations as defined in 12B. And that appears on appendix page 177, which is the indenture agreement. And then this changes, of course, once the operating obligations are repaid, then all of the tax levy tools can be used to then pay down all the remaining legacy debt, which again is what Treasury told Inkster to do just a few years ago. And then, of course, the master indenture terminates once all of the obligations, the operating obligations are repaid. And the legislature was aware of this indenture agreement at the time 2016 statutes were enacted. I want to address two things about this alleged switch or transfer of the obligation to levy an operating tax. I still don't see any statutory provision anywhere that says that happens or when that happens, aside from when DPS is fully dissolved. It's just not in the statute anywhere or any of the statutes. And to answer Judge Reardon's question or inquiry about what happens to the money that is already collected by DPS, that cannot be transferred over to the new district until it is dissolved.
When is DPS going to be dissolved?
When it pays off all of its debt. And that's going to be dictated in large part what this court decides. Because of course, if they can use the operating tax to pay down the debt, they'll be able to pay it down much faster, almost a decade faster. If they can't, and they're limited to the 13 mils on the remaining debt, which we don't believe they are, there's nothing in the statute and in the statutory provisions that limit the use of that operating tax. It will take roughly until we understand like 2044 or so to pay it off, which is going to result in an additional $400+ million of interest alone to the citizens of Detroit.
There'll be another ballot proposal. Hopefully that'll pass.
Well, that's not certain. If and when it comes time to have a new district put to the voters, a proposal to certify the authorization of levying an operating tax, it's uncertain whether that will pass. But until DPS is dissolved, we don't believe that happens because, of course, under 12B, they're obligated to continue levying the operating tax for DPS until it's fully dissolved.
Now, DPS will be dissolved if we don't rule your way, correct?
It will eventually, once it pays off the debt.
Yeah, I'm sorry.
It's just going to take a lot longer.
Right.
But in the meantime, because DPS still has to levy the operating tax under 12B to pay off all that debt, if that debt's not paid off, it will just keep collecting the operating tax money, which it can't by law transfer at any time before dissolution to the new district. 12B makes that clear. 12B subparens 14 says that only once it's fully dissolved, that's when any quote remaining assets of the qualifying district, that's DPS, are transferred to the community district, end quote. Before that, the money that they collect under the operating tax that they're still going to be continued to levy is they cannot transfer that until it's dissolved. In the meantime, under Treasury's theory, the new district is without much revenue stream. They can't levy a tax because they can't levy a tax while DPS is still levying its tax, and they're telling us that they're withholding the foundation allowance. So how the new district is going to be funded at all is a mystery under Treasury's theory, if we're right on all of the other items. With that, Your Honors, I welcome any other questions. Otherwise, we'll rest on our briefs, and we appreciate your time.
Thank you very much.
Thank you.
Thanks to everybody. That case will be submitted, well argued and briefed. Move on to item number 7, docket number 373-182.
Can I step back? We'll issue a supplemental order for the additional briefing.
Yeah, we can, I think for I'm not sure for briefing, but for the material that
Yeah, yeah. So we're allowed them to brief it?
Yeah, we can work on it later, I guess.
Yeah, okay, we'll issue.
So
supplemental.
we'll issue something before the case goes under submission so that you'll have an opportunity to supplement.
Thank you, Your
Okay,
Honor.
thank you. Yeah, thanks, Judge. Okay, calling item number 7, docket number 373-182, Gary Jack Van Huysen versus Michigan Automobile Insurance Placement Facility.
Good afternoon, Your Honors. Lauren Brzezinski on behalf of the Michigan Automobile Insurance Placement Facility, the appellant in this matter.
Good afternoon.
Before the court is an issue that has recently been rolled on in a number of cases and part of an issue that has not. Plaintiff had a policy of insurance with auto owners where he made a valid and effective opt-out under 3107D. He was involved in 2 accidents. Only the second accident is subject to this case, in which he is making a claim for allowable expenses only through the assigned claims. And the trial court granted plaintiff's motion and adopted a number of rulings that frankly aren't supported by the statutory interpretation, nor are they supported by this court's prior rulings on this issue. Specifically, the court held that an election under MCL 53107D makes the policy no longer security under MCL 53101. There's really no support for that. The statute, when you read it, says quite the opposite, and the holdings by this court either have expressly stated it is a policy or implicitly ruled that it is a policy, and referring to Donner v. Progressive University Neurosurgicals versus Auto Club, even recently in the Northland Radiology versus Allstate case. Every policy that has been issued under 3101 provides a voluntary option for lesser coverage, similar to someone who's making that voluntary election for a lower level of coverage under 3107C. It is still a policy of insurance. It is still valid in the state of Michigan as security. To rule otherwise, as the trial court did, would take all of those opt-outs out. Those people would not have security. They would not be insured individuals in the state of Michigan. They'd be driving without the proper security under 3101. That wasn't the intent of the amendments on 2019. The intent was to save individuals money, save cost of the car insurance, and the plaintiff in this case took advantage of that. He's an individual with Medicare. He opted for the Medicare coverage to be primary for his medical expenses. He also opted out of wage loss because of his age and the ability under 3107. There's no dispute that he still could claim replacement services through the auto owner's policy. And so the limitation is to allowable expenses and whether or not that could be sought from a secondary no-fault source. The court also indicated because it's not a policy that was considered under 3114.1, which would be a policy issued to the plaintiff, household resident, relative, or any spouse. Both of those things, like I said, in the cases that this court has come out with, it's inaccurate. It's an inappropriate interpretation of the statutes. In doing that, the court then says, well, because this policy is not a policy and it does not fall within the policies contemplated under 3114.1, this policy doesn't come into play when we look at whether a pedestrian is entitled to benefits through the assigned claims under MCL 531.15. 3115 specifically refers you back to MCL 531.14.1 before you can come to the assigned claims. Under that statute, the plaintiff must look to his own policy of insurance. Because he elected to not maintain allowable expense coverage, he cannot seek that coverage elsewhere. There is no case law and there is no statute that allows an individual to split no-fault benefits. I'm going to go to one entity for one benefit and another to another. The ruling is also contrary to plaintiff's own contract. Plaintiff signed a contract with auto owners, specifically warned him of the risks of not maintaining allowable expense coverage, and he signed off on that knowing that he would not be entitled to those benefits. There are a number of instances in the policy on the deck page where it says you are excluded from those coverages.
Well, he's not asking for the benefits from his insurance policy. He's asking for them from MACP. So
Yes.
I'm not, I mean, I don't want to make too big a point of this, but I'm not sure he's really doing anything contrary to his policy with his insurance company.
Correct. But when you look at it, when someone comes to the assigned claims, they have to be eligible for those benefits subject to MCL 53171 to MCL 53175. The importance of the exclusion language, both in the statute and in the plaintiff's own policy with auto owners, is looking at MCL 53173. That precludes a person from recovery of benefits through the assigned claims if they are subject to an exclusion of a policy between 3101 and 3116. He is subject to an exclusion based upon his voluntary election under 3107D. The court also has indicated with respect to the eligibility element under MCL 53172(1) that, and this is unpublished, but I do believe it's the persuasive opinion of the court in the American Physio versus State Farm case, that because the policy with a valid opt-out is an applicable policy to the loss, that individual was not entitled to come to the assigned claims for benefits because of the identification and availability of other insurance.
Yeah, I mean, this tricky thing here is that 3172(1)A doesn't say no PIP policy is applicable to the injury. It says no personal protection insurance is applicable to the injury. And so I think we have to sort of figure out, if we're using 3172(1)A, we have to figure out what it means when they say the insurance is applicable to the injury. He doesn't have coverage. And then, you know, the question is whether coverage and applicable are different things. I take it you would say they are. But I think that's a little tricky in 3172 as well.
I do think that the court needs to look at, when we look at personal protection insurance coverage throughout the statute, it is multiple things. Oftentimes we refer to it as, you know, PIP, or it's allowable expenses medical coverage. They are all individual things under 31071. So a policy under 3101 statutorily provides for all of those possible benefits. And under the reform, the individuals get to voluntarily elect what types of coverage they would want. But it is still all personal protection insurance coverage. And there is no avenue through the statute to allow them to say, okay, I have what we would call replacement services, right? Those ordinary and necessary services. I can get those through them, which is a PIP coverage, but I can't get my allowable expenses. So I'm going to come over here to the assigned claims and separate those two claims out. There's just no statutory avenue for that. There's also no case law that would support them to be able to make an election and then seek benefits through the assigned claims, which is paid for by the policy holders in the state of Michigan. There are fees that go on to every policy. Individuals like the plaintiff in this case who made this voluntary election got 100% reduction. His policy premiums are quite small because he's not paying for any allowable expenses and he's not paying for any wage loss. The statutes, when read as a whole, indicate that it was a policy for personal protection insurance coverage, and that he voluntarily subjected himself to exclusions under 3107D, but also if you're reading into 3109A. The policy can provide for exclusions or reductions as long as there is a premium that is attributed to or a reduction in the premium for individuals. And this court actually indicated in the Love v. Rudolph case that when you are reading 3109A with 3107C or 3107D, that they have to be read in tandem, which would provide for an exclusion. The court indicated again in the recent Mary Freebed v. Esurance case, well, that had to do with the motorcycle priority issue, that when you look at 3107D, it provides the coverage levels applicable under 3114.1. So it reaffirms that this policy is a policy and that those levels would be subject to the provisions in 3114.1 to allow an individual to both utilize 3114.1 and 3115 through the assigned claims to recoup benefits that they have voluntarily said, I do not want through the auto insurance entities in the state of Michigan, and come to the assigned claims. It essentially renders all of those policies pointless if individuals are not in their own vehicles or in a car, and defeats the purpose of saving money under the reforms, as the court had indicated, even in the Andari case. That entire intent was to save costs.
So can I ask about there's a comparison that the appellees make, plaintiff makes between two parts of the statute. One is the part of the statute where if you are an occupant of a vehicle, and that's 3114.4, and it says, okay, if you're an occupant of a vehicle, you go, give me a second, but you go to MACP, except if you have opted out, right? I think that's paraphrasing a little bit. That's essentially what it says. 3115 talks about non-occupants of the vehicle. And it also says that you go to MACP, and then it says except as provided in section 3114.1, which I get the argument there. But it doesn't add that same sentence that it added for the occupants. And so the plaintiff argues that, well, you know, the legislature must have had some reason to insert that sentence in the provision about the occupants, but leave it out from the provision about the non-occupants. What is your explanation for that omission, other than maybe just the legislature was working very, very fast and it was very busy and they didn't make the two completely parallel?
Yeah, so I think it goes both ways, right? I could argue that they could have specifically said anyone with an opt-out can come to the assigned claims, and they didn't. And I do think there is a reason for that. When we look at 3114.4, it starts with except as provided in subsections 2 and 3, because individuals who are occupants of vehicles could be an occupant of a personal or a commercial vehicle. The commercial vehicles, either employer furnished and or transportation network, are subject to different portions of the statute. Pedestrians aren't. Pedestrians or non-occupants are not subject to those other portions of the statute. And so when 3114.4 starts, it says, obviously, and except as to commercial vehicles, subsections 2 and 3, you can come through as long as you do not have a policy of insurance under subsection 1. Again, still subjecting you to 3171 and 3175. However, under 3115, it does specifically refer us back to 3114.1. And so when plaintiff makes the attempted correlation between subsection 4 and subsection 5, or excuse me, 3115, they're not the same because of those different types of individuals who could make benefits if they are occupants of a vehicle. So I don't believe that the legislature needed to add that specific language in 3115 because it already refers us back to 3114, in which—
Okay, so the 3114 reference kind of takes the place of the extra sentence that they added on to the occupants.
I believe it does. And if we specifically are looking at, it's talking about the policies, personal protection insurance policy described in section 3101 applies to accidental bodily injury for the person named in the policy. That would be plaintiff's auto owner's policy in this case, because he's subject to the contractual exclusions and his statutory exclusions. He would be precluded from those benefits there. And there is no statutory avenue to allow him to then come to the assigned claims for those benefits. I also think they did not require that language in there because at the end of 3115, it says that your claims through the assigned claims are under 3171 to 3175. And it is this court's indicated in Steenhouse versus the MAIPF, even if they are in the order of priority, those claims are all still subject to any potential statutory exclusions contained within the assigned claims plan statutes, which would be not only 3172.1 that I've mentioned previously and that this court talked about in the American Physio case, but also the 3173, which would preclude recovery of benefits because plaintiff had an exclusion under the policy with auto owners. And so I do believe that the trial court's ruling from the beginning was incorrect with the statutory interpretation as to whether it is a policy of insurance or not, and all the way through as to whether or not the individual may come to the assigned claims for specifically allowable expenses. I will reserve time for rebuttal if the court has any questions for me at this time. Thank you.
Thank you very much.
May it please the court, Stephen Sinus on behalf of plaintiff and appellee Gary Van Heusen. Good to be with you today. A few introductory remarks to really set the stage here and make sure that we understand the stakes. There are thousands of senior citizens who are trying to save on auto insurance by buying this new option that's made available to them as a result of the 2019 amendments, where they are agreeing to forego one specific type of no-fault benefit, and that is an allowable expense benefit. And this is a very unique option. When you look at it and how the court has examined these options, this is the only option where a person is allowed to buy a policy under 3101 that does not have a specific benefit, does not have allowable expenses. So senior citizens are buying these policies. The question this court is here to resolve for all these people who are buying these policies today and going forward is that when they are walking as pedestrians down the road, did they somehow lose the right to recover no-fault benefits that all senior citizens had for the first 40 plus years of no fault?
Isn't that more of a policy question than a legal question?
That's a very good question, Your Honor. And what I'm trying to set the stage here with is that for 40 plus years, the legal
They had the
question,
new, I mean, as counsel said, it was kind of put together quickly, the No Fault Act, the new
Well-
No Fault Act. They made mistakes. Shouldn't that be something that the legislature goes back?
and this gets into the substantive remarks I have. It was my introductory comment, but to segue into the substantive remarks, what this court is tasked with is a mighty big challenge, and that is to assess what the legislative intent was when they went into the No Fault Act in 2019 and changed 3101, changed 3114, changed 3115, and even changed 3172. Did the legislature mean to take away the right of senior citizens who buy opt-out policies to participate in the medical coverage available to injured people when they are hit by motor vehicles as pedestrians? Did they mean to do that?
Well, the statute says something, we have to follow it, correct?
It does. And I want to walk through the court.
Even they may have made a mistake in writing it. They should go back and correct it. We can't correct it for them.
I would like to take the opportunity to try my best to convince you that there's not a mistake here, that there's a clear answer that the legislature has set forth. It's maybe not clear on first look, but when you look deeper into what they did, and it begins with 3101. They went into 3101, and we're not saying, contrary to what they're arguing, that opt-out policies aren't valid legal auto insurance policies. They are. But what they did in 3101 is they said you can comply with 3101 if you're an opt-out or by buying a policy that does not have allowable expense coverage. And they, in passing 3101, they didn't change the other language in 3101. They went down and changed the specific language that's in 3114 and 3115. And so the question becomes, what are the rights of these people, these senior citizens who buy these opt-out policies when they're injured in a crash? Do they have allowable expense coverage from anywhere? And the legislature went into 3114.4 and answered that question. It says they can't go to the assigned claims facility. But the more important point to make about what the legislature was doing there is that they were recognizing that by virtue of now buying a policy under 3101 that doesn't have allowable expense coverage, they are not covered with allowable expense coverage for 3101 purposes. And that's precisely why they went into 3114.4 and changed it. 3114.4 begins with a person who suffers accidental bodily injury arising from a motor vehicle accident while an occupant of a motor vehicle who is not covered under a personal protection insurance policy as provided in subsection 1 shall claim benefits to the assigned claims plan. It goes on to say this subsection shall not apply or does not apply to a person who's insured with an opt-out. We're urging the court to recognize that what that really shows from the specific language of the legislature is a recognition that under 3101, these people don't have coverage for purposes of allowable expenses. Now, the legislature went one step further and said, okay, that might be true, but we want to bar them from making these claims from the assigned claims plan. And that's why they put that sentence in there at the end of 3114.4. They wanted to make it sure that a lawyer like me trying to argue that they didn't have allowable expense coverage under 3101, that they couldn't go to the assigned claims plan. But they didn't make that change in 3115. And I want to urge the court to.
But in 3115, the who is not covered clause isn't in there either.
That's true,
right?
but
There's
under,
a difference between the two subsections.
it is true, but again, emphasizing that 3115 was completely overhauled as well. 3115, prior to the 2019 amendments, didn't have any reference to going to the assigned claims plan. They put it in there. And so the question becomes, and this is what they're ultimately hanging their whole hat on, it's that by saying except as provided in 3101, that means that it negates and renders really totally meaningless to these people the next part of 3115.1, which is that they can go to the assigned claims plan. The ultimate crux of their argument is that there's a trap door there under 3101. And what we're urging the court to recognize is that the legislature in passing 3114.4 was saying, no, these people are these unique class of people that we've created through these amendments who don't have allowable expense coverage. We said in 3114.4 they can't go to the assigned claims plan, but they didn't do it here in 3115. And that's of very, I think, important significance in terms of the legislature taking action in one section and not taking it in another. So
in the pre-no fault reform world, if you're not an occupant and you got hit by a car, obviously if you have no, if you don't own a car and your family members don't own a car, you have no coverage, you would go to MACP. But if you did own a car and you did have the mandatory comprehensive coverage, you went to your own no fault company, right? You wouldn't go to MACP.
actually, under the
In the old world.
prior to 2019, what you just said at the end there was right. If you had your own policy, go to your policy, but you actually wouldn't get to the ACP until you work through a number of other policies.
Yeah, you'd have to go through the priority.
Right, and they overhauled all of that.
Okay, yeah.
And they said all these people now go to the ACP if you don't have your own policy. It would, the thing I really want to emphasize here is the canon that you can't interpret a statute to render it nugatory or for it to be mere surplusage. And that's the only way to make sense of what the legislature was doing. Or I shouldn't say that's the only way to make sense. I'm saying that our interpretation of 3114.4 is the only way to avoid an interpretation that renders that second sentence in 3114 nugatory or surplusage. I mean, why would they go in there and put that sentence in there if they felt that these people truly had coverage under 3101?
Well, it's because, and I'm just proposing. Yeah. I think one might say it's because in the first sentence of 3114 subsection 4, they wrote who is not covered. And so once they wrote who is not covered, they had to sort of counterbalance that by saying, oh, but if you have a policy and you opted out, you don't go to MACP. Now, for whatever reason, they didn't use the words who is not covered in 3115. And maybe we can ask why they didn't do that. But once they didn't use the words who is not covered, it seems like that second sentence is less important. I don't know if you're following what
I totally follow what you're saying, and I'm trying to make sure that I respond in the most, helpful and accurate way. The purpose of 3114.4 is to address situations where people didn't have their own policy under 3101. That's the first point of 3114.4. So if they're right, why would the legislature even comment about opt-outers? That to me is the most direct way I can pose this question to the court. Why would they put that in there if they're right? They're wrong. 3101 was changed to take out allowable expense benefits. That is a very new development in the law. That is a revolutionary change in the Michigan no-fault law. That's what makes it a hard question for this court to consider, but it's not a slam dunk like they're making it seem. These people opted out of a specific benefit. What does it mean going forward in terms of their rights to claim that benefit? Are they always barred from it, or are they barred from it as occupants and not as non-occupants? We're obviously arguing that they're not barred as non-occupants. We have no issue with it being the result that they're barred as occupants. And in fact, with regard to their premium arguments, these people did get the benefit in their premiums of not having allowable expense coverage when they're injured using their motor vehicle or anyone else's motor vehicle. But how can it be the case that in buying this opt-out coverage, they are also taking away a right that every other senior citizen who doesn't buy auto insurance has? If you don't buy auto insurance and you're hit by a car, you get to go to the ACP. Is it really the case that senior citizens are buying a product that takes away a right? We say it's more accurately described as buying a product that doesn't provide them a right under their own auto insurance policy, but doesn't take away a right that is there and available to everyone else in their class of people. And with regard to 3172, we are aware of this Steenhouse decision. That decision focused on or dealt with a situation where a person was trying to claim ACP benefits for injuries in an accident that occurred out of state. There's a direct provision or direct language in 3172 that says they only pay benefits for accidents occurring in the state of Michigan. And so what the Court of Appeals correctly recognized is that that is a specific statement that ultimately carries the day with respect to whether the 3111 argument prevails over the 3172 eligibility. They're saying that the legislature put the language in 3172 and it specifically says you only get it for an accident occurring in the state. So even if 3111 could be interpreted to being providing coverage, it doesn't specifically and explicitly address it like 3172. In this situation, we have the legislature.
So you're on 3172, is your position that it is the case that no PIP insurance is applicable to
that is right, Your Honor. Yes.
Now, what about the fact that the plaintiff does have survivor's loss and replacement?
Yeah.
Isn't that PIP?
And actually, I said yes, and I was answering your question. I should say that our answer to the question is that the preamble of 3172 says you can claim PIP benefits from the ACP if any of the following are true, and it says no personal protection coverage is applicable to the injury. Ultimately, even though the priority statute doesn't expand coverage under the ACP, it is very relevant to that first prong of 3172 about whether there is coverage applicable to the injury. And as far as the draftsmanship saying personal protection coverage applicable to the injury, we recognize it doesn't specifically say no allowable expense coverage. But if you put it all together, we're not claiming any PIP benefits from the ACP that he could get under his policy. It's only the allowable expense coverage. And with respect to there being statutory indication that the legislature was okay with this bifurcation of benefits, at the end of 3172, they put a very specific limit. It's 3172 sub 7 that says the ACP is only required to provide personal protection insurance benefits under 3107(1)A up to whichever the following is applicable. And it goes on to state the $250,000 limit on allowable expenses. So there is a recognized statutory framework within 3172 that the ACP could just assess its liability with respect to allowable expenses, and that's capped at $250,000. So it's not outside the bounds of what the legislature was contemplating with the role of the ACP. Ultimately, it is patently unfair to treat these senior citizens who are buying policies in such a way that strips away rights that other people who don't buy insurance for their vehicles or just don't even legally participate with auto insurance would have if they're hit by a motor vehicle as a pedestrian.
So are you saying that if you have a senior citizen who is legally obligated to have a no-fault policy and doesn't, it's a violation, that they get injured as a pedestrian, and under the current system, despite the fact that they are in violation of their legal obligation to have a policy, they can still go to the ACP?
Yes, they can.
How do I know that?
You would look first at, well, first of all, to walk you through the complete analysis, 3105, there'd be accidental bodily injury arising out of the use of a motor vehicle as a motor vehicle. The next question would be, would there be a disqualification under 3113? None of the provisions would disqualify a pedestrian in those circumstances. You're only disqualified under 3113B if you are the owner or registrant of a motor vehicle that you're using at the time of the accident. So your vehicle that needs to have insurance could be in your driveway, doesn't have insurance, and you walk down the street to your friend's house and you get hit by a car. 3113B disqualification would not apply. And there's no other disqualifications that would apply.
So then where's the obligation that they're violating to have a policy?
Well, it would be the fact that they have a car sitting in their driveway that they're not buying insurance on. So when they get in the car, they would be disqualified. But we put this hypothetical in our brief. We had Dorothy and Blanche.
Right.
Yeah, Dorothy bought the opt-out. Blanche didn't. She actually didn't even buy auto insurance on her vehicle, and they both are walking down the road and they get hit by a drunk driver. And ironically, Blanche is in a better position than Dorothy under their reasoning.
That's why it's illegal not to buy insurance when you're required to, right? I mean, it's probably just a misdemeanor, but it's we try to deter these types of things.
I think really the importance of what I'm trying to get at is that are these opt-outers actually depriving themselves of a right that everyone else has? And there's no clear legislative intent to do that to them. And there's a clear framework that I hope that came across here in my remarks today that shows that the legislature has clearly attempted to save them from such a fate.
There's no dispute in the case that the opt-out was effective.
Thank you.
Thank you very much.
Just a couple quick points to make. There is an avenue for individuals who make a valid opt-out under 3107D. It is MCL 531.35.3C. That says that now, because of this reform, individuals can make damages for allowable expenses, work loss, and survivor's loss as defined in 3107 to 3110, including future damages, et cetera, for individuals who have made limitations under 3107C and 3107D. That's the avenue. That was the intent by the legislature. They created higher BI premiums, or excuse me, BI limits to deal with this issue of not only the caps, but also any elections and opt-outs that people may have. The plaintiff in this case had two tortfeasors that he sued in another case. That's where those benefits get paid because of his voluntary election under the auto owner's policy. And I do know, there's questions as to whether or not they knew or would know that they may not be entitled to this coverage. There is a PIP election form attached to our appendix that everyone has to sign. It is the same for pretty much every carrier that I have seen so far. And when it defines option 6, which is the option we are talking about today, it says in all caps, no PIP medical coverage will be covered under your policy. You and any other persons covered under this policy will not have PIP medical coverage. You and those persons may have to rely on other health coverage to pay medical expenses resulting from an accident, which may or may not cover all of your benefits. They're warned of what the potential liability might be if those are expenses. And they have said, my Medicare is going to pay for it. And then the legislature gave them an avenue of recovery through the BI case, which he could and did pursue in this case. So the argument of, well, these individuals who are elderly or Medicare recipients, they didn't know that this was going to be possible, or they're left kind of in the lurch versus other individuals who don't have those benefits. That's not the case. The statutes were changed, the limits were all changed to accommodate for these additional exclusions or additional claims that may be made because of the other issues that were raised in the reform. And so they're not left without recourse or left without an avenue to obtain these allowable expenses. And as it pertains to the situation that appellee raised in their brief, Dorothy and Blanche, they're two very different individuals. As Your Honor pointed out, at the time in which they're walking, there was no obligation or legal requirement that Blanche be insuring her vehicle that is not involved in the accident. If Blanche is involved in the accident in a car, that is a different story if she's driving her own insured vehicle. But Dorothy, or plaintiff in this case, voluntarily elected under the statute, under the risks, to obtain a policy of insurance wherein they were warned that there would be no allowable expense coverage through a no-fault carrier, statute then allows them to go to the third party. So there has been intent by the legislature to address these issues, but you have to read the No-Fault Act as a whole. You have to read it entirely instead of piecemealing some of these statutes and ignoring parts of other statutes that don't work in favor of the arguments being made. And so because there is that avenue, there is no ability for these individuals to come to the assigned claims for parsing out of certain benefits that would apply under the policy that was applicable. And so we, again, Your Honors, ask that the court reverse the trial court's ruling. There are any questions? I'll take those now. Thank you very much.
Thank you very much to both of you. Again, well argued and briefed, and that case will be submitted. I think we're going to take another quick break, and we'll be back to take up the next item shortly. Thank you.
Appeals to State Admission, but not in session, to see.
Okay, welcome back. Thanks very much for your patience. We'll be continuing now with the 11 o'clock hour of our call. We're just a little bit behind. Item number 8, calling item number 8, docket number 366769, Affiliated Diagnostics of Oakland LLC versus Homeowners Insurance Company. Good afternoon.
Good afternoon, Your Honors. Martin Radner appearing on behalf of the appellant, Affiliated Diagnostics. I'd like to reserve 3 minutes for rebuttal, and I understand that I have to keep track of my own time.
Okay.
This case returns from the Michigan Supreme Court after it ordered the Court of Appeals to grant leave, which I believe was done to correct a manifest injustice. The district court judge in this case, Judge Burke, who presided over both trials in this case, intimately very familiar with the facts and the no-fault law, issued an 11-page opinion in which he laid out his reasoning why he was granting MCL 53148 attorney fees. That opinion was appealed to the circuit court, and the circuit court judge, in a 3-page opinion, made findings that Judge Burke, his findings were clearly erroneous, and that he abused his discretion in awarding those attorney fees. It's my opinion, Your Honor, my position that the circuit court is the one who made the error, not the district court, Judge Burke, and that's why I'm going to be asking to reverse the circuit court, reinstate Judge Burke's opinion, and remand back to district court to finalize the hours in this case. I know Your Honor's read the briefs, so I just very briefly want to go over some of the important facts which have a lot to do with the legal argument. In March 31st, 2017 is when Cherie Thurmond was in a severe, serious car accident in which both cars were totaled. She was extricated from the vehicle on a stretcher with full spinal precautions and rushed to Henry Ford Hospital. Luckily, she made a recovery. A number of tests were performed, and she was eventually discharged with instructions to follow up with a specialist. She did follow up with a specialist. That specialist ordered MRIs. Those MRIs were performed at my client's facility, Affiliated Diagnostics of Oakland. Affiliated Diagnostics of Oakland billed Homeowners Insurance Company on June 19th, 2017. That's the important date. With the submissions, Affiliated also submitted the MRI reports and the prescription for the MRIs. The MRI reports detailed severe and serious herniations in Cherie Thurmond's back. At the same time, Homeowners also had in its possession the Henry Ford Hospital records, the pictures of the cars that were totaled, and the police report. They also had the specialist records. Despite having all of these records, Homeowners sent 1 page of a correspondence saying that the claim is under investigation. There was no further correspondence sent from Homeowners for another 16 months.
Explanation of benefits involved here, correct?
Explanation of benefits were sent.
Who was sending those?
Homeowners.
Homeowners.
Homeowners sent that first explanation of benefits around the time of June, July of 2017, saying the claim's under investigation, and that was it. No further correspondence was received for another 16 months when the third claims adjuster assigned to this claim sent a letter laying out some generic reasons why they're denying the bills. The IMEs in this case were conducted a full year after the submission. They began a full year after the submissions and continued right up to trial, into the second trial. Surveillance was conducted, but that was also conducted a full year after submissions. The deposition of Cherie Thurman was conducted a full year, more than a full year after the submissions of the bills. So what did homeowners have to rely on to deny the bills is the million-dollar question, which after 9 years, we still don't know the answer to. Now, Cherie Thurman did have some pre-existing injuries. Those pre-existing injuries were exacerbated by this severe motor vehicle accident, and homeowners did not find out about that till many, many months, at least till after the denial.
After the denial or after the 30-day denial window?
Yeah, I'm sorry, that's what I'm referring to as the denial. After the 30 days that they have to decide on the case. So that's operating to me as a denial. Eventually the case went to trial. There was a verdict with interest, and that created a presumption that the denial was unreasonable. That's what the case law states very clearly. And then the question then becomes, did homeowners have a bona fide factual uncertainty at the time of the denial? And at the time of the denial is when we have to look at, that's what Evisage versus Auto Club Insurance Association and a number of other cases say, you got to look at the time of the denial, not what they found out a year later when they started sending her to IMEs and conducting surveillance. What did they know at the time the 30-day window was up? What did they know at that time that they can rely on and claim that they had a bona fide factual uncertainty? And the record is completely empty. There's no attachments, no exhibits. After 9 years, they still are scrambling to try to make some sort of cohesive argument that they had something to rely on, which they don't.
But ultimately, the verdict that is not being challenged at this point, at least directly, is a sub $800 verdict, right? So the second jury found that there's an entitlement to some, but relative to the full amount requested, it's a small amount. How should we think about that here? I mean, obviously that looms large, right? You have about $90,000 judgment or so, and a $800 plus $400 of interest is the verdict portion. So, I mean, is it your position that doesn't matter, that disparity, and or tell me how it does matter and why it doesn't affect the integrity of the award here?
Sure, absolutely, Your Honor. And I would say, and I would urge this court to do exactly what this court has done in the past. And this is in the case for Commandant versus Gifford, which is a Michigan Court of Appeals case in 2020, where the verdict was $107. And the award of attorney fees, which was upheld by this court, was $235,000. So the Court of Appeals already has binding precedent that the amount of the verdict has nothing to do with the sanction. And that's what 3148 was created for. It was created to sanction an insurance company so they can't squeeze these tiny providers with these bills and just not pay them for 9 years and run them out of business. That's exactly why they created 3148, for these exact situations. So yes.
I mean, Purgu, at least, right, among the factors is the result obtained. So presumably that provides, some nominal or, space to consider the quality of the result. And obviously you have a win here, but, a small, monetary amount to show for it. So, that didn't seem to trouble the district court judge. And I guess why should we not be troubled by it either?
Yeah, well, I don't think you should be troubled with it because we have binding Court of Appeals precedents in Commandant versus Gifford, and as well as Tinnen versus Farmers Insurance Exchange, which say that the amount of the verdict has no bearing on the amount of attorney fees. As we just showed you, $107 is a verdict and $235,000 is attorney fees. In Tinnen, the verdict was $1,200 and the award of attorney fees was many, many tens of thousands of dollars above that. So, and I would say that issue that's brought up in Purgu is similar in Smith versus Curry. That has to do with the rate, I believe, in how to determine how much this attorney is worth. That's one of the many, many factors that go into that analysis. What rate do we put on this attorney? Not do we not award a substantial amount of attorney fees? So that's what I would respond to that, Your Honor. Coming to the question of whether as we're talking about whether this fee is reasonable, and how do we determine whether a fee is reasonable? Well, one of the ways is to see how many hours is the plaintiff claiming. In this case, the plaintiff's counsel claimed 252 hours to have spent on this case with 2 trials and a very lengthy appellate process. The defense in this case, the homeowners insurance company's attorneys admitted that they spent almost double that amount of time. So they can't get up and argue that 252 hours is unreasonable amount to spend on this case when they themselves have spent 444 hours on this case, which auto owners presumably paid for, which they presumably assume is reasonable. There was also a full evidentiary hearing that was held at the time. Plaintiff's counsel took the stand. He submitted a itemized billing charge showing exactly what he did on the file. He was subject to cross-examination. Judge Burke went through the factors in Smith versus Courier, all those factors, and that's how he determined a reasonable rate. So any argument that the fee is not reasonable is going to fall flat. Another interesting issue that was brought up on this case is because this was a case tried in district court where there's a $25,000 jurisdictional limit, this is one of the arguments that my brother counsel makes, is that therefore the attorney fee should be limited to $25,000. And for that, we also have binding Michigan Supreme Court authority, which says that that's not how it works with attorney fees. The jurisdictional limit is not bound by attorney fees. The attorney fees, it's exclusive of attorney fees and interest. This is also in Crossick versus Detroit Automobile Inter-Insurance Exchange. So even though this case was tried at the district court level, attorney fees are not capped at $25,000.
Unless it's a contractual fee. Is that right? We have that case law that
Yes.
recognizes. That's your position, is that the contractual nature of that makes it a damages award that folds into the jurisdictional amount.
I couldn't have said it better myself. That's exactly what that case stands for. It's a contractual, has nothing to do with the no-fault statute. And yeah, it has no bearing on this case. Another very interesting issue, and one of the more novel issues that we're going to get into that this Court of Appeals has to make a decision on, is the appeal time. There was a lot of appeals in this case. Even though it was a district court case, we went through multiple appeals. There's 2 separate appeals. The first appeal actually had to do with the verdict. The first appeal was on the verdict. And the question that one of the arguments that my brother counsel made is that the appeal time should not be compensable. After all, they won that appeal. We have to try the case again. And that, for that proposition, is just, there's no basis in the law for that, because the Court of Appeals, in a binding decision, Blomsamo versus Auto Club Insurance Company, says that no appeal time could be compensable under 3148, which, if Judge Burke relied on, would then obviously not be an abuse of discretion if he's relying on binding Court of Appeals precedent.
And doesn't that kind of fold into whether the hours spent on that appeal were reasonable, and if they were spent pursuing a meritless goal or objective that makes them less likely to be reasonable than if they were spent pursuing an objective that had merit?
Well, ultimately, I think the question is, are these hours spent to recover overdue PIP benefits? You're not going to win every motion either.
Right.
So just because you unsuccessfully argue a motion, that time is still going to be recoverable because it's all in the effort to recover these unpaid benefits. So even though you may have lost the appeal, all the time is spent in an effort to recover, which was eventually recovered with interest. So I think what's more,
I mean, if the other side has to file a motion to compel discovery and you lose that motion, do you get to recover fees for the time you spent fighting the other side's motion to compel discovery? That's not the case here. This is a completely hypothetical, but the reason I bring it up is because there is this situation where you lost the appeal. At the same time, you would have, all the time was eventually led to a victory, although a fairly small one. So,
yeah, and I like the question. I would argue that affiliated was put in a position because of certain rulings that a judge made, and now we are stuck with arguing that appeal. And even if we lose on that issue because of the judge's rulings, affiliated shouldn't take the brunt of that. We're still arguing for our PIP benefits. You're not going to win every motion. You may not win every appeal, but we're still the ones fighting for our benefits.
So maybe you're saying you might want to look to who made the error that created the necessity for the appeal, that kind of thing?
Well, I wouldn't say that where should we be looking? Because the case law, I believe, is clear that as long as your effort is to to get paid the unpaid benefits, to recover the unpaid benefits, it's all compensable. So you'd be running down a slippery slope. So you lose appeals. Okay, say we take away, okay, a lost appeal. Then where do you start with motions to compel? Where do you start with motions for summary disposition that people can spend hours and hours on? If you lose that, does that not compensable? You can't start parsing it off like that.
But presumably, I mean, even if there's not a categorical rule about it, presumably you end up in the judge, looking at various factors to assess sort of like the reasonableness of the fee. Are you saying that the judge couldn't fold that into that sort of reasonableness assessment, or just that there's not a categorical rule about it before it gets to the judge?
It's a very interesting question. Would the judge be able to consider that as part of his reasonable analysis? I would say that the judge is kind of stuck with the Court of Appeals decisions. And unless he finds in a Court of Appeals where you're allowed to do that, I would say that that's unreasonable. And from my research, I haven't found a Court of Appeals decision that says that appeal time is not compensable. I only found cases that say that it is compensable. So I think what's very interesting in this case specifically is that here we have the second appeal. And the second appeal, like your honors pointed out, is limited to 3148 attorney fees. So the question is, what about all this time that we're spending on this second appeal, which we went to the Michigan Supreme Court already at this point? So all that time, is that compensable? And we have a very interesting decision in McKelvey versus Auto Club Insurance Association, which is a Michigan Supreme Court case. In that case, the issue in front of the courts, the appeal issue, was only 3148 attorney fees. That was the direct issue. However, in that case, the court made a point of saying that the insurance company has already paid the verdict. And because they paid the verdict, the only issue and the only thing that the attorneys were going after were 3148 attorney fees. In this case, it's quite the contrary. Believe it or not, homeowners has still not paid the verdict. So they are waiting for this issue to be litigated, apparently, until they are willing to let go of the PIP benefits that are owed to my client.
$1,000.
Yeah. So this is all, even though the direct issue in front of your court, the court today, is just 3148 attorney fees, but it's all in order to obtain that unpaid benefit that is still in the homeowner's hands.
Now, you started out talking about how long it took homeowners to decide this claim, and they hired an investigator. They did a number of things. It took a very long time. All turns out that was justified.
It turns out that, I'm sorry?
It was justified. You sought $19,000 and you got less than what? Less than 800. All right. So all those efforts turned out to be justified. Should they be penalized for that?
According to the case law, they should. They didn't pay $800. They paid zero.
Right.
They
They
paid
will
zero.
pay- At some point, they're going to have to pay the $800, won't they?
At some point, will they have to pay? Yeah, at some point, but why should I mean, the whole point of 3148 is to sanction is.
So you would have been just as happy back when they issued the EOB with $800 as just as happy as if you received 19,000.
I would say that that's much more of a reasonable approach, but.
Suppose they could have made an offer of judgment, right? They could have, if they thought the case was only worth $780, they could have made an offer of judgment earlier in the case. And if you never won above what they thought the case was worth, that cuts off the attorney's fees after the offer is rejected. I'm pretty sure they didn't do that, so.
There was zero offer on this case for the entirety of the.
But the question would be, are they in a position to make that offer of judgment? Or did they need to investigate further?
Well, I mean, they're in a position whenever they want to make an offer of judgment. I mean.
Sure they are. I mean, we all are.
Sure.
But certainly I'm not going to make it without having some educated basis for making it.
Sure, but then the question would be, why wait? Why wait?
They investigated it. You went down a whole litany of things they did.
They didn't start doing those things until a full year after the submissions of the bills. If they want to investigate a claim, they can, but they should just
It's
get on
within
it.
the 30 days.
Within 30 days, that's what the statute provides. They have 30 days to investigate the claim. They could have sent her for IME notices, get medical record request. We haven't seen anything because I suspect that there was no investigation in this case until they were sued. And then
I guess, counsel, from your perspective, then, if everything is the same here, it's 30 days, it's still under investigation for them. And they, but they're not in a position to make an offer of judgment or to know. The way it's supposed to work is they should just pay the 19 and then litigate to recover what they ultimately determine shouldn't have been paid.
Well, there is a mechanism. There's 3148 for the insurance companies as well. I mean, if they paid a payment that was fraudulent, they could also obtain 3148 attorney fees. You probably have
Even
cases.
short of that, even if it's not fraudulent, I mean, I'm not talking about the penalty part, but just about how the litigation would unfold, like how things should have happened here. Because obviously we're in a space of penalty, right, which contemplates there's something that has happened that's gone wrong. So the thing that's gone wrong here, as I surmise from your position, is that we hit 30 days, and at that point, you know, if you're still under investigation, like what should the insurer do? Just pay it, and then kind of go about litigating, figuring out whether they should have paid all of it, and then try to get what they think shouldn't have been paid back? Is that what should have happened?
They should do two things. They should, number one, notify the claimant about what investigation they have undertaken, what their findings so far have been, what they're doing, let them know what's going on, what the process is, and they do need to make a determination after 30 days to pay whatever they feel is reasonable. So if their investigation is saying, you know, we're going to find a lot of things here, we're already discovering things, okay, maybe we won't pay, we'll take that risk. Or we'll say, we're seeing a lot of funny things, but maybe we'll, you know, a reasonable amount would be such and such, so we'll do it. But if there's no action at all taken on a file for 16 months, that's unreasonable. And that's what happened in this case. So that's why, Your Honors, I believe that the circuit court's ruling should be reversed and Judge Burke, the district court, should be reinstated and be remanded to finalize all the hours in this case.
And the finalizing of the hours would be to account for what? Everything that's happened since?
As we're standing here today.
Your position falls within the scope because the verdict amount has not been paid.
Because the benefits have still not been paid. They're still being held by the insurance company investing them for the past 9 years. So yeah. So, thank you.
Thank you, Your Honors. Good to see you all. Jonathan Freshour on behalf of
Once
homeowners.
again, I didn't recognize you, and even though I saw you last.
Oh, really?
Changed dramatically from his time at the Court of Appeals.
Thank you. I appreciate that. I will be as quick as possible. I understand all of this has been briefed. There's just a couple of things I want to touch on. There's a number of interesting issues in this case, and I was noticing in Brother Counsel's argument, and also since the day I graduated law school, that all of them seem to come down to the word reasonable. So it's intersecting on every issue. What is reasonable? I think by far the most important issue in this case is whether there was a bona fide or bona fide factual uncertainty when homeowners denied this claim. In order for benefits ever to be due, there has to be reasonable proof of loss and a causal connection between an accident and the loss that was sustained. And I think there's a little bit of burden shifting in plaintiff's argument about when that proof of loss was ever provided in this case. It's plaintiff's burden to prove at first that their injuries have some level of causal connection that then triggers homeowners' burden to pay. I understand plaintiff's suggestion that homeowners is kind of over-relying on trial evidence that certainly they could not have relied upon prior to trial. So I'm going to try to focus a little bit on just what was inarguably available to homeowners almost immediately. And that is, this comes from the deposition testimony of homeowners adjuster Charles Rosenthal. But
he was not involved at the time of, he only became involved in this file later.
Right.
Okay,
So I believe he's
personal knowledge of this
pontificating, but he, I think, probably has the claim records and is generally aware of when things are received. But inarguably, the emergency room records. There was no diagnosis, no suggestion of an injury in those emergency room records. Then we have the visit to Dr. Huari. I'm not 100% sure how to pronounce that, but he has a treatment plan which appears to be associated with pain. MRIs are not indicated as necessary in that treatment plan. We then get 4 MRIs approximately 2 months later, which are, I will say, a little suspicious on their face, but particularly in light of Dr. Huari's treatment plan. And all of these are just bases for homeowners to question whether there was a causal connection between the accident that occurred and the $20,000 that was requested.
Did anyone testify as to those facts being actually factually under consideration at the time within the 30-day period? Or was this just testimony afterwards that said, well, looking back on this, this could have been
There
a
was
question.
some testimony from that insurance adjuster who was looking back about when auto owners had, at what point they had procured these records. So the question was auto owners reviewing them at that time? So that was the purpose of that testimony. I would say, I think the reason we're here today, this case did not present an incredibly high number for auto owners, is that they felt so strongly about their position here at all times and their uncertainty about the causal connection between the injury.
But there wasn't, maybe I misunderstood your
Yeah.
response before. There's
Sorry.
not like an affidavit or testimony in the record that says, hi, I work for auto owners, and within this 30-day period, these are the records I was reviewing, and these were the conclusions I was reaching about the validity of these claims.
I would say that there is, and it's the testimony of Mr. Rosenthal.
Okay.
Now, he was not the one reviewing at the time, but I think he's referring to auto owners' records of what was being reviewed. If that answers your question, there is no.
Maybe I'm just trying to get the sense of like how much of this is after the fact and how much of this is like at the time. And maybe it's not dispositive, but I'm just.
Well, I think it actually does raise an interesting point, which is in that timeline of things taking so long, these records are obtained by the testimonies by the end of June 2017. This lawsuit was actually filed in the no-fault world, which I would like to say sometimes I'm more involved than I want to be in, relatively quickly in September of that year. So this lawsuit was ongoing. Auto Owners was defending this action while investigating it, which is not completely out of the ordinary, but the IME that was obtained in light of this. I'm certain one might have been obtained eventually, but this litigation was ongoing. I think that's an interesting point to make in terms of how long this timeline is that litigation began pretty quickly. But that's not to say that an investigation wasn't occurring beforehand. It certainly was. Records were being produced. Auto owners paid the emergency room bills related to this accident because there was no question that the emergency room visit was necessitated by the motor vehicle accident, which is also one of the reasons we know they had those records. The point being, I think this case paints a pretty clear picture of what a bona fide factual uncertainty is. Auto owners had a lot of reasons to question. The fact that they then uncovered a mountain of evidence that confirmed their suspicion doesn't mean that their initial uncertainty was invalid. And I don't think it would be appropriate in every case. Certainly, I will take from this going forward that insurers should be very careful in arguing this issue about timelines, and when certain evidence is obtained and maybe keeping track of that and noting it. But I don't think it would be appropriate to require insurers to essentially prove a negative. The purpose is a plaintiff is required to show reasonable proof of loss. And I don't think it's the job of an insurer, after trial, to explain why the proof itself is insufficient. The records that were given to auto owners to suggest a causal connection were insufficient. With that, I will just briefly touch on some of the other issues. I think that issue controls this case, but I would also argue the amount of fees aren't reasonable. This is, as your honors noted, a $789 verdict and award for $90,000 of attorney fees. And I think,
Counsel, just to confirm, is there any dispute that the verdict amount has not been paid?
I don't think there is. I'm glad you asked that question, Your Honor, because that is not, I want to say I don't believe auto owners would have any issue paying that verdict today. I don't think it's been really a discussion because I think the parties have been focused on these appeals, but I don't believe.
But they haven't.
I don't believe that they have. I think the appeal was taken. One of the issues in the initial appeal, we're not arguing today, was that homeowners was entitled to a special jury instruction on the issue of fraud. So they were seeking to overturn the verdict. And I think that $789 there's certainly no issue paying that, but just kind of got lost in the shuffle of we are arguing these issues. Nope, there's been no demand for that money. So.
And I know I understand that you've presented it in your brief this way, as we're not challenging the verdict based on the special jury instruction, but you are still challenging that instruction, as a way to reinforce a favorable ruling on the part of the case that financially is more consequential to you.
I'm sorry, could you I don't think I fully understood.
You've put the fraud instruction you've still put in play. Just I understand you're trying to insulate the verdict while arguing it at the same time.
Correct. Yeah,
so
no, that's true.
you have a verdict that's not been paid.
Yeah, that's
and you
correct.
still have a legal issue, that is pertinent to that verdict, except based on how you're trying to frame the argument around it. So, when I think about sort of if we, disagree with you in terms of the propriety of the award, then you have to determine sort of when that award, what it should comprise.
Right.
And, to the question of, did the appropriate time period for that award end sooner? I'm trying to figure out the right way to think about that in light of McKelvey and the fact that we don't have a verdict that's been satisfied yet for whatever reason, even though we're nominally not challenging its integrity.
Yeah, I guess my answer to that, because it stuck out to me that I didn't think fees for example, today were really in question until today, but I think although we may include some argument related to the jury instruction in our briefing, I think it's pretty clear that we haven't appealed that issue. We appealed the attorney fee issue and that issue, and we won on the attorney fee issue and lost the jury instruction issue, and we did not appeal our loss of the jury instruction issue, if that clarifies it all.
But you're still arguing the issue to your benefit on this appeal.
It would appear maybe not to our benefit, but no, it's raised.
Yes.
I think it is raised as an alternative basis. Something I would point out is, and I want to revisit this case on a separate issue. I will be very quick, but the Hodge case that plaintiff relies on relates to this because it stuck out to me the idea that we will continue to pay what I would categorize today it would be fees for fees. Ordinarily, you are not entitled to recover the attorney fees that are come out of your attempts to recover attorney fees. It's usually referred to fees for fees. In Hodge, which was a case about subject matter jurisdiction related to the district court jurisdictional issue, there's an entire paragraph, it's the last paragraph of that case, about the court saying we understand that there could be circumstances in which a party could draw out a case to increase the value that it has. I'm not saying that plaintiff is doing that today, but I am saying that that's something to consider in light of the fact that really this is $789 that auto owners would have paid. And I do feel that this was there's not been a demand. There's not been a discussion. The discussion has been about these appeals, and these appeals since the Washtenaw Circuit Court issued its opinion, the issue has been the reasonableness of attorney fees. Just a couple quick issues, other things. So I think I said this is a very large award for $789, and the Wood factor, I believe Brother Counsel was asked about it. There is an explicit factor to consider under Wood. It's well established in Michigan. That is the amount in question and the results obtained when determining an attorney fee. I also, I do not believe that it is a frivolous position to take that auto owners did win the first appeal, and some fees associated with that first trial and first appeal. Again, the question comes down to what is reasonable. here. Another issue we raised that I think, assuming this case is not resolved by the bona fide factual uncertainty issue, is that hours were not adequately tracked. I think the issue is less about an argument about the amount of hours that were expended, and more about whether we can reasonably rely on the tracking method under Augustine. With that, Your Honors, unless you have any questions, I believe I addressed most of what I wanted to. I believe the bona fide factual uncertainty issue is relatively clear in this case. And frankly, I think were it to go the other way, it could be somewhat of a dangerous precedent in terms of insurers paying and chasing. And the purpose of the No Fault Act is to reduce premiums, and there has to be an ability for insurers to investigate claims that appear on their face to not be causally connected to an accident.
You're not challenging the hourly rates that were set, is that right? That's not part of the.
I don't believe that. It is in our briefing. We're challenging the hourly rates, but I think that the district court resolved that issue. We didn't.
The main issue is the hours, and then any the reasonableness of the hours. So.
Yeah, and I know we briefed the hourly rates. I will say I also understand that Attorney Radner is a great attorney, and the rate in this case was not, I think, out of the ordinary. Thank you, Your Honors.
Yep. Thank you. Thanks.
Well, actually, Your Honors, the purpose of the No Fault Act was to ensure prompt payment of PIP benefits. That's pretty clear in the case law. So it's also to lower insurance premiums, but also the point, which is straight out, is that to ensure prompt payment, not 9 years waiting of payment. It seems like insurance, auto insurance or homeowners insurance wants us to hold their hand and make sure they don't lose checks in the shuffle, and that if we don't make demands for payment when there's a verdict sitting on their desks, then that means that they don't have to pay. I mean, this is part of the problem. This is exactly why we have 3148 attorney fees, so that you have auto insurance companies not waiting for small providers to remind them to pay them. In terms of the causal argument that was made, there is nothing in the record. Exactly as Judge Corbin said, there's no affidavit. The only testimony that was talked about in argument was testimony that I spoke about in my reply brief. And in that testimony, the adjuster said, talking about what he's received up until that point, which was all just the records that I spoke about, the Henry Ford records, the affiliated records, the specialist records. And in those records talking about causation, the specialist said that all these injuries that he associates in his medical records, the back pain, the radiating neck pain, all the issues that she had, he relates directly to the car accident. There's no question, there's no uncertainty from, and this is in Exhibit 11 in the appendix, if you want to look there. Probably there's a claim record. They had 9 years to produce a single record showing what they had at the time. We can't say probably at this stage. You got to show it, and they can't show it. Interestingly, there's a comment about filing months after the denial. Keep in mind, you have 1 year to file or you lose that claim. So we're not going to wait up until the deadline. Can't expect providers to say, well, maybe the insurance company is going to become reasonable all of a sudden. So, yeah, they did file a couple months after the denial, after 30 days have passed, and that's what the law provides. In terms of the hours being tracked, and I'm a little surprised to hear this argument, that I guess there is some sort of argument that 252 hours are not reasonable when defense counsel admitted to have spent over 444 hours. So perhaps if plaintiff's counsel would have tracked his hours, it would have been more like 400 hours. So I'm not sure if that argument is also going to sway why that should be considered unreasonable for a plaintiff to claim 252 hours. There's no requirement for tracking hours. The only requirement under the statute is that the fee be reasonable. And that's all we're asking for in this case. And Your Honors, that is.
Can I ask about the fees on fees issue? Is your argument that McKelvey is distinguishable because the verdict has not been paid in this case, whereas had the verdict been paid right after the verdict was entered, that might be we don't have to go there because that's not an issue.
That's exactly it. That's exactly, as long as the insurance company is holding on to the benefits, whatever's going on to stop them from paying, which apparently at this point is the 3148 issue, it's all in action to recover unpaid PIP benefits. So it's recoverable under 3148. Thank you, Your Honors.
Thanks. Thank you. All right. Thank you very much. That case will be submitted. We will now turn to item number 9, docket number 367737, Andrea Rose Muldowney versus Philip Carey Muldowney. Yeah.
Good afternoon, Your Honors. My name is Dennis Brewer. I represent the defendant in the lower court, Philip Muldowney. Mr. Muldowney is back in the gallery, was sitting with me during the earlier cases.
Thank you.
Thank you. This case comes before the court after a bench trial in the 44th Circuit Court. The parties in this case resolved issues as it related to their parenting time, custody, and child support. The court conducted a trial as to the property issues in this divorce action. And there are 4 issues in regards to lower court's decision that are before the court for this appeal. The first being the disproportionate share of equity that was awarded to the plaintiff in the judgment of divorce. The court's failure, in our opinion, to properly divide the defendant's, my client's rollover 401k, the failure of the court to specifically award personal property to my client and or half of the value of the personal property, and then the court's failure to award spousal support to my client. I'm going to rely significantly on the brief that was filed and then also my reply brief, but had a couple things that I wanted to highlight as it pertains to each of the 4 issues. The first one being the disproportionate share of the equity in the home. That issue was made up of a few components. Some monies that the court ordered had to be taken out of basically the proceeds from the sale, including some cleaning fees, what the court ruled as necessary things for the plaintiff to get the home sold. There was an issue of a E-Trade account. Why I bring that up is it ended up in a disproportionate share of the equity in the marital home to the tune of about $26,000 if you add up the different things.
And what was the amount that got taken out and then the rest got split equally?
Correct.
So what was the amount that got split equally?
I believe about 130, either 131 or 113,000 to each.
So collectively about 260-ish.
After those things.
After the 26.
Correct. Yep.
Okay.
So as it pertains to those issues, we made some various arguments at the lower court level as to why those weren't applicable. In essence, what happened is the plaintiff was in control of the sale. She thought it was necessary to create some staging. She ordered pods to be delivered, property removed from the home.
The house was quite filthy from what I saw on the record. Didn't it have to be cleaned up?
That was an assertion that was made by the plaintiff, Your Honor. However, if we go back to the testimony of the realtor who sold the home, he testified that it needed a little bit of cleaning. And I did notice in the brief filed by the plaintiff, they talked about how
Included pictures too, I think, didn't they?
I believe the pictures may have been pictures that we introduced during the course of the trial. As it pertains to the assertion by the plaintiff that basically that my client was living there on his own and didn't take care of the house, what the court should understand is that it wasn't just my client living there. It was the marital home that the parties had lived in, and he had the children with him. There were 3 minor children. And the children lived there with him 6 out of 14 overnights during this period of time. So it's not that my client was living there on his own, just making a mess of the house. He was, seeing and visiting and taking care of his children for 6 out of 14 overnights during that time. But I think the key point is the realtor who sold the home indicated that the home needed some cleaning, but did not talk about it needing all these different things. So we believe that the order from the lower court that awarded the plaintiff an additional $26,000 out of the sale proceeds was an abuse of discretion. The second issue relates to the rollover IRA that belonged to my client.
I think there's an unpublished case that supports you.
I believe so, and I believe you were one of the judges who made that
You're correct.
this decision. And I would argue to this court that the facts of this case are remarkably similar to that case.
That's what I thought as well.
I think that if there were ever a situation where 2 cases mirrored each other, it's this case and the Robach case.
I think Robach also worked at Ford.
I believe that's correct. And ironically enough, we have almost the same length of marriage, a 10-year marriage. I think also.
It's unpublished, so maybe we got it wrong.
What's that?
It's unpublished, so we could have gotten it wrong.
I don't believe you did. There was also a commonality in terms of the funds. It was fidelity in both situations. In essence, there's 2 errors that took place as it pertains to the lower court's ruling as to the rollover IRA. The first being the fact that my client had a buyout pension from a previous employer. He worked at Johnson Controls prior to the marriage and then even 5 years into the marriage. Why this is important and very distinct is that the pension was completely earned prior to the marriage. My client had an ability to get some sort of annuity and or a lump sum buyout when Johnson Controls decided that they would award that to him. The award of that took place after the marriage, but the entirety of the pension was earned prior to the marriage. There was no testimony presented at trial to refute that position, that was all premarital money that my client earned during the time he worked at Johnson Control prior to the marriage.
Once they got the fund, the buyout, then they put it in the IRA.
The money was transferred to the IRA, correct?
So in that sense, the Robach case is still relevant because there's a question of whether that they're by putting it in the IRA that commingled.
Correct.
Those funds.
And I think we also rely on the Skelly case that I cited in the brief, and that dealt with the retention bonus. That it was kind of the opposite. The bonus was paid out after the divorce, and the Court of Appeals decided that because it wasn't paid out during the marriage, it wasn't a marital asset. And similarly here, it was all earned prior to the marriage, and although it was paid out during, that was all earned prior to the marriage.
Let me ask you this. Is your position that the amount that is due to your client is just the amount that was paid out, or also any sort of appreciation of that amount after it was put into the IRA?
It's our position that similar to
I forget how much it was. Was it 60?
So the pension buyout was 49 and some change.
Right, 49. Okay.
So it's our position that he's entitled, that should have been awarded to him along with the premarital portion of 126. Because he had 126 at the time of the marriage, and the judge did correctly say, that's yours. I'm going to separate that out. But in essence, what the judge did is say, at the time of the trial and her decision, the total amount in the rollover IRA was, I believe, $471,000. And she said, I'm going to only subtract the 126 and change that you had prior to the marriage, and plaintiff gets the balance of that. She didn't even take into account the $49,000 pension buyout, which we believe she should have.
To be clear, took out that 126, that was the value of the account at the time of marriage, and said, this goes to your client.
Correct.
And then took the remaining balance and split that equally.
Correct.
Okay. Right. And what you're saying is to that 126, the 49 should have been added because it was earned prior to the marriage, just like that was, even though it wasn't received until later.
Correct.
So that should have been a, 175 amount.
Correct.
And then your argument also, though, is that once that's done, then the court should look at the remaining balance and, per the Robach case, kind of trace the amount of the appreciation that's attributable to that 175.
Correct.
And also give that to your client. And then the rest gets split.
That's correct.
Okay.
And what I think what got lost, I think in this, and as I said, the judge didn't take out and separate the $49,000. On top of that, ironically enough, Mr. Cunningham, who did the analysis in the Robach case, was a plaintiff's expert witness. And I think I argued this in the brief that in essence, he didn't come in to do an analysis. He came in to give his legal opinion that Robach's not the correct law for the court to follow, and that somehow the court needed to follow the McNamara case. And I believe during the testimony, Mr. Cunningham, he acknowledged that what my client tried to do was the exact same thing that he did for Mr. Robach. And I believe he solidified our position that our case here, similar to Robach, is distinguishable from McNamara. Because they said if you can't trace, if you can't do that, then you have to award it because there's no way to know. But in this case, it was able to be traced.
In Robach, the trial court credited the tracing theory.
Correct.
And this court said, okay, in your case, the trial court did not credit the tracing theory, and you're asking us to say, oh no, you must credit, right? That's a little bit different because our standard of review, I don't think this is, I mean, we can talk about this, whether this is really a de novo type of review that we do of this kind of thing, or whether we defer to certain determinations that are discretionary or fact-finding with the trial court.
I do agree in terms of the decision by the lower court in Robach differed from our case, but the facts are pretty much the same. And I mean, 3, 4, 5 times, Mr. Cunningham during his testimony agreed that if our expert did the assessment and analysis the same way that he did, that you could trace this. And that's why I think the McNamara case was different and different from our case too, because in that case, there wasn't the ability to trace where we could do that here.
I think as I read the court's, analysis of this issue and its findings, it didn't seem like it had problem with the idea of Robach. It just didn't find the issue presented in a way that it felt comfortable following it. It had issues with the fact that Cunningham couldn't verify through his own review the integrity of the analysis that had been performed by is it Mr. Bradford?
Bradford, correct.
So that it seemed to be less of a intellectual or analytical disagreement with Robach than just sort of like, well, based on how this came in before me, I'm having I'm not going to follow. I don't feel like I can implement it. So, I mean, is there what do you see as sort of the error in the judge thinking about this case that way?
Well, I think and in part I'm going on the argument made by the plaintiff is that Mr. Bradford never testified as in this capacity, and that Mr. Cunningham was more reliable. And I go back to the fact that if Mr. Cunningham's reliable, he did the same analysis that Mr. Bradford did in the Robach case, but in this case, he wasn't hired by the plaintiff to do that. He didn't do that. As I said, I believe the purpose of his testimony was to try to instruct the judge on what the law was, not the analysis of this. And he agreed that if Mr. Bradford did the analysis, and I don't think there's anything to refute it. And there was no other analysis done other than the analysis by Mr. Bradford, who did the calculations and explained how he did it. And it's our position that that fell in line with what Mr. Cunningham did. And not only did Mr. Bradford do that, but also my client did that himself, and explained during the course of the trial that it's based on having a spreadsheet and using arithmetic. I think he described as ninth grade algebra, that if you can do those two things, if you can have a spreadsheet and do ninth grade algebra, that you can make this determination. And I don't disagree with that.
As a father of a ninth grader, it's, touch and go.
Easier said than done.
That's probably true. But at the end of the day, there really can't be a challenge to the analysis done by Mr. Bradford, because I asked Mr. Cunningham there, he didn't offer any testimony to say, I looked at this and based upon the information that I have, the math is incorrect. And at one point during Mr. Bradford's testimony, he said, I was hired to do the math. And that's in essence what we should be concerned about in this case, in this particular issue, is the math of it. Because although it's an unpublished decision, there is, at least the persuasive argument that if you can do the tracing, that's appropriate. And when the case that's relied upon to say you can't do this, or it's a law of the land, so to speak, that was a case where you couldn't do this. So I believe the judge did err when she, in essence, wouldn't look at the actual mathematics done, but just said, I find Mr. Cunningham to be more reliable. As it pertains to the personal property and the issue of the spousal support, the personal property, there was I don't think there's any dispute that the value of the personal property was somewhere between $56,000 to $60,000. As I indicated, the first issue regarding the disproportionate share of the award of equity, in essence, what happened is the plaintiff kind of was in control of how the property got divvied up. And in essence, my client was kind of left with property. She had the ability to take whatever property she wanted, and she did. And we believe it was there. There are specific items of personal property that may not have much value to people at all, but they had value to my client, that the judge refused to indicate that he would be awarded. And basically she said, I'm not going to deal with this anymore. Lastly, the issue of the spousal support, I would rely mostly on the brief, but I do think that the reliance upon kind of the catch-all that if there's an equitable distribution, or my client got all this in the, this other property in the division, that an award of spousal support or a refusal to award spousal support was appropriate. In essence, we have about $56,000 or so that have been tipped to the side of the plaintiff by virtue of the disproportionate share of the equity distribution, and then also the fact of all this personal property. So for the reasons we outlined in the brief, I would indicate that I also believe that the judge erred in the failure to award the spousal support. And I'd reserve a few minutes for any rebuttal unless the court has any more questions for me.
Okay, thanks.
No.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Katrina Slesky. I'm subbing in for Mrs. Jordan Ayler Smith today. She's out. She's the one that wrote the brief, but I'm here to argue today. Mother Apelli is also in the courtroom, and she's been watching some arguments this morning. So first of all, I would just like to address your question about the remaining equity split in the marital home. I looked up the number, and the split equally was $119,079.14 was what it equated to be equal distribution after the trial court made the distributions to mother. So
$240,000 about total that got split equally after the 26,000.
Correct.
Okay.
Yep. Yep. So The trial court, we don't believe erred or abused its discretion in awarding Mother Apelli the additional distributions for cleaning up the house. There was testimony that the house was in disarray when she arrived in October 2022. She had to buy pods, hire movers, get vendors for staging the home for the sale. And then we also don't think the trial court erred in any of the other distributions that was given. We also don't think the trial court erred in splitting the rest of the equity in the home. I mean, really, it comes down to a 51% Mother Apelli award, 49% Father Appellant award. So there's really only about, according to our math, about $10,000 difference here in a estate worth about $700,000. So we don't believe that it was error or a significant deviation from congruence to award the additional $26,000 to Mother before distributing the rest. For the rollover IRA, there was a lot of testimony about the experts in this case and what they found as to the statements. The trial court did find that Mr. Cunningham was more reliable in his testimony based upon that there was 5 missing statements, so he couldn't adequately trace any of the premarital versus marital contributions to that account.
Well, I think the testimony was he couldn't verify the tracing that had been done himself.
Correct, yeah. So I believe Mr. Cunningham reviewed what Mr. Bradford had done in the tracing.
In looking at the testimony, it seemed like there was and this issue kind of ended up getting discussed, that it looked like Mr. Cunningham had printed out a copy of the report, and on that printout, some information was missing. When he looked, that he said, well, I can't confirm these numbers because I'm missing some information that Mr. Bradford had. And then, but that's how I understand the record. Is your understanding different, or?
No, that would be our understanding as well of the record. However, I know that the unpublished case, Robach, has been talked about a lot today. And I would distinguish it from this case because in that case, they were able to trace, and because the trial court in our case found that Mr. Cunningham was more reliable in his expert testimony, that we can't rely on Robach as controlling in this case when we have McNamara, which is a published case, and the court is mandated to follow its prior precedent.
So you read McNamara as being in conflict with Robach as opposed to sort of just being silent on the issue, and Robach distinguishes McNamara? Sorry, if that was not a very clear way of putting the question. Because I'm trying to figure out if you have a position regarding, assuming for the sake of argument that the experts have all of the information at their disposal and they are able to do this so-called tracing, is that an acceptable mechanism for a trial court to use if it wants to divide up the estate?
So I would argue that tracing is an acceptable method.
Sorry, is or is not?
Is.
Okay,
Is an acceptable method. However, in this case, I don't think the facts support that the premarital was traceable from the marital. Therefore, they were commingled, and that's why the trial court didn't err or abuse its discretion in the award of the rollover IRA.
And also just, I guess, a record question. I didn't really see anything in the court's findings that seem to expressly account for the pension buyout. I understand ultimately it ended up in the pot that got split equally, but I don't remember seeing discussion of that piece in the court's findings. Is that your understanding as well?
I don't think there was much discussion about the pension buyout.
There was some testimony about it, and it's just to establish what it was. I don't remember the court actually kind of addressing that piece of the pot.
Let me see. Sorry, I'm just pulling up the transcript from. So it looks like the trial court talked about a $49,000 loan from father's SSIP account. And she rolled that into the retirement accounts and asked that to be included in the balance for the retirement accounts. I don't see anything specifically about the buyout. However, there wasn't evidence about specifically where it came in. I looked at the statements provided and brother counsel's brief, and I didn't see exactly where it was included in the rollover, that specific payment. So I just would argue that the trial court didn't err in that fact as well in making those factual findings. As to the personal property issue, there was some argument today by brother counsel about some specific property that they were looking for and that the trial court just didn't want to deal with it anymore. However, I know there was extensive testimony about the personal property. There wasn't testimony about specifically what mother and father each had in their possession at the time. So we just argue that the trial court found that the total personal property was about 60,000, and the trial court awarded each person their personal property in their possession, and that was not an abuse of discretion. For spousal support, I'll mainly rely on our arguments in our brief for that issue. We would just like to point out that the trial court did not err. The trial court considered the spousal support factors. Trial court considered the length of the marriage was about 13 years. There wasn't any testimony that father needed any financial assistance. Both parties had worked during the marriage. They were both educated, earned high earning jobs, close in range. So we're talking about mother earning about 144,000 at the time and father earning about 137,000, which isn't that different. And then the trial court also just considered that that both parties were in good health and that it also considered his age. So therefore, based on the factual findings by the trial court, as regards to spousal support, we don't find any error there either. Therefore, mother respectfully requests that this court affirm the trial court's orders in all respects, as the trial court's decisions were adequately supported by facts and the circumstances of this case and was therefore equitable. Any questions? No, thank you.
Thank you very much. Mr. Brewer?
Thank you. Just a couple of points. As to the question regarding the pension buyout, the court didn't address that at all in the oral opinion that she gave. Counsel brought up the $49,000 loan. That's a separate retirement account that my client began when he started working at Ford Motor Company after the parties were married. So that was included in a separate, that's a separate retirement plan. So in answer to the court, there was no discussion by the judge whatsoever regarding the pension buyout, despite both sides filed closing arguments in that case, written closing arguments after the trial was completed. As to the issue regarding the personal property the condition of the home, counsel talked about the fact that there was testimony that the home was in disarray. That testimony was by the plaintiff. And I believe, and I would indicate to the court, I think that may fall into the realm of a self-serving statement, and that she had control of the possessions because my client was no longer in the home and was abruptly not in the home anymore. And as such, she had control of what property was there. And so I think if we go back to the realtor who said at the time he went to go list the house, it needed to be cleaned a little bit. I don't believe that justifies the, close to, $15,000 in expenses that the plaintiffs decided to incur. In terms of the personal property, as I indicated, the plaintiff could decide what was going to go and what she was going to take and what my client was going to be left with. And although there was testimony about it, my client specifically indicating things of personal property wanted, the judge just said, I'm not going to deal with it. I'm paraphrasing. She didn't say, I don't want to deal with this anymore, but she said, the court's not going to spend any more time, I think is exactly what she said on this. And the parties are going to keep what they have in their possession. And other than that, I think I didn't mention this before, but if the court looks at the at the statements and the analysis that Mr. Bradford did as it pertains to the tracing. There were due to the length of time that this trial took, Mr. Cunningham testified in October of 2022. I think mid to late October of 2022. Mr. Bradford didn't testify until March of 2023. And there was a number that was done as of October, but then Mr. Bradford did the continued analysis up to March. So he didn't just stop at the October. So Mr. Cunningham did look at the spreadsheets that Mr. Bradford did, but there were additional timeframe because there were more statements that came in and the account was different in March as it was in October. And so Mr. Bradford did do the analysis up through March, which increased the amount that ended up being the marital because there was more money that grew over those 5 months or so. It's our position that the amount that Mr. Bradford made the determination was marital and should be divided was $118,000 out of that, not what the judge did, which was the $471,000 minus the $126,000. So it's our position that Mr. Bradford did do the correct analysis, did follow the tracing method, and there was no evidence to contradict that the math that he did was incorrect. And if there's no other questions, that's all I had.
Great. Thank you both very much. Have a great afternoon. That case would be submitted. The next case is item number 10, docket number 372-896, 12-5 Capital LLC versus Aquaforum Watercraft LLC. We've been advised that the appellant has waived oral argument. So that brings us to the appellee.
Good afternoon, Courtney Evans, appearing on behalf of Appalachia North Shore Dock. Because appellant is not appearing today, I am just here to answer any questions that the panel may have. Otherwise, we rest on our briefs and ask for the lower court decision to be affirmed.
Well, thank you very much for being here.
Thank you so much.
That case will be submitted.
Thanks for sitting here so long.
That's all right. I like listening to everybody.
Good. Have a good afternoon.
You as well.
The next case is item number 11, docket number 376681, in re AJ Gilmore minor. And we do have oral argument reserved by, I assume you're Mr. Deal?
Yes.
Yeah. Thank you.
Thank you.
Welcome.
I hope the court doesn't mind if I use my laptop. I'm completely paperless now, but may it please this honorable court, Ryan Deal appearing on behalf of the respondent father in this matter. This case comes before you on an appeal from termination of parental rights out of the Shiawassee County Family Division. In this is kind of comes from a little bit of a unique kind of perspective. The case was brought in based on criminal charges that were brought against the respondent father. Respondent father was convicted of those charges, and at the time that the termination of parental rights petition was before the court, respondent father was had been convicted, and that matter, his conviction was on appeal. Mother was.
Has that been resolved yet?
No, I actually just checked this morning. It is not. It's. I think though that it's been. They've noticed for case call, so it will probably be argued within a month or two. So respondent mother rather was never made a respondent to the petition. The children resided with mother. At the trial in the matter, father's counsel requested an adjournment, and the adjournment was mainly so that they could seek a resolution of the appeal. The resolution of the appeal would directly, if the case was overturned, it would directly impact one of the statutory bases, if not all of them. Actually, it would directly impact one of the statutory bases. It would indirectly impact all of them. And so he made this request. The LGAL indicated that she didn't see that there would be any real harm to the children because an adjournment would have absolutely no effect on their placement. So she found that the request at least met the test, the LGAL found that under MCR 3.923 that there was good cause because there was some merit there. The trial court, and the children were residing with mother. Father was at the time incarcerated. He'd be incarcerated at all times. So there'd really be no change or impact on the child if they were to wait and see how this case was resolved. Nevertheless, the trial court determined that they wanted to hear the evidence in order to give some sort of finality to the child. Now, there wasn't really too much established on what that would be or what that meant, but the trial court indicated that that's what it wanted to do. I'm arguing that that was an abuse of the trial court's discretion, as there was simply nothing before. There was a good cause. I mean, in fact, everybody, at least there didn't seem to be in the transcript much of an argument regarding whether or not there was a meritorious issue for the appeal. So again, the trial court just wanted to, proceed on this matter expeditiously and moved forward to trial. Naturally, there wasn't much of a trial because father had, asserted his Fifth Amendment rights, and so there wasn't much of a trial. The next, and like I say, we argue that it was an abuse of discretion not to grant the adjournment because there really just wasn't anything that would have impacted the child in any way had they adjourned it to see how the criminal appeal panned out. With respect to best interest, this is another one that's kind of a little bit perplexing to me. With respect to the best interest findings, once again, the court never really had any testimony with respect to.
Sorry, you're not talking about the best interest finding regarding the adjournment. You're talking
No,
about
now thank you.
Sort of underlying
That's
determination best interest.
Yes, I kind of moved on to the
That's
best
fine,
interest findings under.
Be clear.
In that case, again, like I say, what I find kind of interesting about the best interest findings here is there was normally in these cases, we'll see a psychological evaluation to make a determination about the bond. Instead, they had an individual get up there and kind of testified more generally about Maslow's hierarchy of needs and things like that on behalf of the child, but never really connected that to this particular child to make any kind of individual findings. But what's kind of the logical problem that exists in this particular case with respect to best interest is no matter what happens in his criminal appeal, it's very hard to understand how a termination of parental rights benefits this child in any way. Okay, if his criminal appeal were granted, well, then the underlying basis for the whole thing is gone. He returns home, but wait, he can't return home because he's got his termination of parental rights. He's still married to the mom. They never filed for divorce. The child's still living with mom. I don't know what path it creates, like this almost absurd path. If it's granted. If it's denied, on the other hand, I think he's incarcerated for it will be the entirety of this child's minority. So he will be incarcerated. This child will be an adult. I believe this child would be somewhere in their 30s by the time he's out. So I couldn't really understand the trial court's findings with respect to the nexus between the best interest of this child, either way that this case comes about. If the conviction is set aside, he can't come home because he's got this termination of parental rights based on something that was based on a conviction that was overturned. If it doesn't happen, well, then he's incarcerated and there's no impact to the child. And not only that, mom hadn't filed for any kind of divorce, but the trial court really didn't give much credit or weight or anything to the fact that if mom's a non-respondent parent, if she feels that this child's in danger and the court, because the state of Michigan hasn't deemed mom to be any kind of danger to this kid or that her judgment is somehow impaired in any way, then I don't understand again, so.
And the child
couldn't she just seek custody? Sorry.
And the child is still with mother.
Yeah. As far as I know, as far as I know in my last. But that's my argument, Your Honors. If the court has any questions, I'm happy to answer them. It really wasn't much. The transcripts were, I think there were 2. It was very, very not a very lengthy proceeding. But those are my arguments, mainly based on logic and the law. court has any questions, I'm happy to answer.
Nothing more from me.
Okay.
Thank you.
Thank you very much. That case will be submitted. Next case is item number 12, docket number 376916, in re Gilliam minors. And Mr. Deal, you're up again.
I am endorsed for oral argument. And in this case has been, I extensively briefed this for my client, on behalf of my client. MDHHS has also extensively briefed this. I think both sides are resting on their briefs. I'm merely here to answer any questions if the court has any regarding the record or regarding our arguments.
I don't have any questions.
No, none for me.
Very good. Thank you very much, Your Honors. Thank
Have
you
a
for your
great
time.
afternoon. That case will be submitted. The next case is item number 13, docket number 376124, in re Moen minors. And we do have oral argument preserved by the appellant remotely. Do we have someone there? That's the last one, so maybe just give it a minute to see if. Oh, here we go. Yes. Good afternoon, Ms. Hemingway. Is that correct?
Yes, good afternoon, Your Honors. Jody Hemingway on behalf of Respondent Father Christopher Moen.
Whenever you're ready. Thank you.
Thank you. I will rely solely on my brief with the exception that I want to make 2 corrections to that. It's been briefed extensively. It was a lengthy proceeding by both sides, and I did make a mistake as it relates to argument number 1. I explicitly remember the trial court indicating that the agency had conceded that it was not proceeding on MCL 712A 19B 3G. So I'm not arguing that. And as attorneys for the agency properly point out with respect to the video recorded statements, it is an error. It's MCL 712A.17B5, not 19. But with that, unless the court has any questions, I would rest on my brief.
No, I don't think I have any. Thank you.
Thank you.
Thank you very much. Appreciate your time. That matter will be submitted.
Thank you, Your Honors. Have a good day.
You too. Thank you. The next item is item number 14. These are 2 cases, docket numbers 377782 and docket number 377783. Those are both called in re Grudzinskas Oliver minors. We have no one endorsed for oral arguments, so those cases will be submitted on the briefs. And item number 15, docket number 377598, in re VL Sikali minor. There's no one endorsed for oral argument, so that case will be submitted on the briefs. And with that, we're done with today's case call. We'll be back tomorrow morning. Thank you very much.